This meeting is being recorded. Under the our executive sir, Professor Dr. G.D. Puri sir, and support from the administration, we are organizing this national CME. This is third in the row. We are organizing this kind of CME since last 3 years. We have chosen the topic, consider the relevance and importance in the present scenario. The topics which is from the area of medical negligence, clinical practices, and from the consent have been chosen. Keeping that in mind, we have also chosen the speakers which are eminent in their field and they have worked in these particular areas immensely and contributed a lot to the fraternity. This CME has viewed immense response and we have received about 800 plus registrations from the country and from nearby 7 more countries. So this CME is intended to address certain issues which is related to the medico-legal practice and medico-legal cases. Keeping that in mind, our advisors, Professor Dr. Mukesh Yadav sir, sir is President, Indian Academy of Forensic Medicine, sir is with us. We also have with us Professor Dr. Adarsh Kumar sir. Sir is professor at AIIMS Delhi, also President of Indian Academy of Medico-legal Experts. We also have with us Professor Dr. Nishat Ahmed Sheikh. He is President of Indian Society of Toxicology. So I welcome all delegates and dignitaries. And with these words, I would like to invite our respected Executive Director, Professor Dr. G.D. Puri sir. Sir is currently working as Executive Director of AIIMS Rajkot and also Executive Director of AIIMS Jodhpur. Sir is having the vast experience in the field of medical education and cardiac anesthesia and contributed a lot to the medical fraternity, published several papers, and he has many things in his name. So, sir, welcome to you, and we would like to get your blessing, sir. Thank you, sir.
Good afternoon. Thank you, Dr. Gupta, for beautiful introduction to this meeting. First of all, congratulations to the organizing team for organizing such CMEs programs, and I'm very happy that you have been able to get 800 people registered, and I can see the people are just logging in, and already 150 people have logged in. I'm sure there will be some physically present also, as you said. I welcome Dr. Mukesh Yadav, Dr. Adarsh Kumar, and also Dr. Nishat Ahmed Sheikh, who have been advising and helping in framing this the CME. And of course, you have national, international speakers who will be contributing in these couple of 3-4 hours session which you are going to organize. And I'm very happy to know that you have been doing it earlier also, not the first one. And the name which you have given, the pearls, penuels, and pitfalls in the management of medical legal cases in clinical practice, that's that's a the correct thing, in the sense, currently whenever you talk of forensic medicine people, you only think of the deaths, autopsies, and those sort of things, forensic related to. That's what I'm not a expert in this, but this is what the general impression goes. But here you are touching all the medical legal aspects, not only related to the typically to a forensic medicine department, but also related to the medical field, especially currently when you are there are a lot of medical legal cases are happening in the form of violence on the doctors, healthcare workers, and the responsibility of the hospitals and administrators becomes more important than just taking care of patients before and after death, but also taking care of and the taking care of the security and the safety of the staff who are delivering these services to the the common man. So, with these words, I wish you all the best, and you continue. I hope you will continue to help your specialty as well as the medical field in guiding in this direction. And the AIIMS Rajkot, which has a very important place in this area, and the one of uh, the aims of these INIs is to not only treat patients but also to increase the human resource development, the form of training of the people working around, and bringing the latest in the uh, all over the world, whatever is latest in the knowledge of the people who are practicing medicine or a particular field of medicine anywhere. Thank you very much and wish you all the best. And hope everyone enjoys these next 3 4 hours of this teaching. Thank you.
Thank you so much, sir. We are privileged to have you with us, and we are really motivated to learn from your valuable insights, sir. Thank you so much, sir, for sparing your time and guiding us that how to go about it. Uh, with these words, now I would like to invite our President of Indian Academy of Forensic Medicine, Professor Dr. Mukesh Yadav, sir. Sir is a well-known figure in the forensic medicine fraternity, and sir is also in the Directorate of Medical Education at Uttar Pradesh. Sir, we would like to get your blessing, sir.
Thanks, Dr. Sanjay. First of all, I would like to congratulate Dr. Sanjay and whole team, Department of Forensic Medicine, for your inclination for academic as well as to be in touch with the pulse of the clinical faculty facing these problems related to medico-legal issues. And your director, Dr. Puri, again, under his blessing, you are able to perform these activities at the national level. And the response, which, as you told, more than 700, 800 delegates, they registered for this conference. So all the participants are requested to attend and add value to your existing knowledge on the medical legal issues, because nowadays with the more awareness among the general public, mostly these faculties or those doctors involved in practice, they are facing issues related to medical legal issues, and every time new amendment or new law come into picture, and the increased number of consumer court cases, and especially after this new the Bharatiya Nyaya Sanhita and Bharatiya Sakshi Sanhita, this consumer court cases, these criminal negligence cases, they have been reported by the National Crime Record Bureau since 2017, and there is increasing trend. So when the public, the patient, your user, they are more knowledgeable than you, obviously you have to face the problem. So for facing that challenge, you have to be keep updated through such type of CMEs. And on behalf of IFM, again, I extend my congratulations to Dr. Sanjay Gupta and the whole team and all the speakers, eminent speakers, to address these real problem in terms of pulse, perils, and pitfalls of the medico-legal issues in clinical practice. Thank you, Dr. Sanjay, for giving me opportunity to share my thoughts on this issue. Thank you very much. Over to you.
The topic which we have chosen, especially in the current scenario, and we are already aware of about your immense contribution in the area of medical negligence, where we get the routine cases and routine references from your end to update the whole fraternity about the recent things going on in the fraternity. We are indebted to you, sir. Now I would like to invite Professor Dr. Adarsh Kumar, President, Indian Academy of Medico-Legal Experts, President IMLI, to share his valuable insight. Over to you, Adarsh, sir.
Uh, Thank you, Dr. Sanjay Gupta. Good afternoon to everyone. I hope I am audible.
Yes, sir. Yes, sir.
Okay, okay. Actually, I was driving on the highway when I got your call, and then I just make some on the sideways. And here, just want to convey my best regards in on behalf of the Indian Academy of Medico-legal Experts in the capacity of honorary president of the academy. I extend my sincere thanks to the organizers led by Dr. Sanjay Gupta, Dr. Utsav Parik and whole AIIMS Rajkot team for inviting me to be part of this very important CME uh, and congratulate them for choosing this very apt topic in the current scenario, the pearls, perils, and pitfalls of the medico legal practice, which is the need of the hour. And I'm sure the speakers will deliberate upon the various issues and all the participants. I'm pleased to learn there are around 700 to 800 participants, and I'm sure they are not only from India; they are from the whole world. The participants are there, so they will be, you can say, they will be more. They will get the knowledge from, and they will become more knowledgeable in this particular field, challenging field, which will be helpful in their day-to-day practice. So once again, congratulate the whole team and so all the best for the successful organization of this online CME webinar
Thank you, sir.
conducted by AIIMS Rajkot.
Thank you so much, sir. Thanks a lot, sir. Your valuable words and insight which you have shared with us, it mean a lot to us. And we hope that we'll continue such online and offline events under the guidance of IMLI, IAFM, and IST in future also. And we continuously need your blessings and support for all our future endeavors. Thank you, sir. Thanks a lot.
Thank
Sir.
you.
We also have with us President Indian Society of Toxicology, Dr. Nisat Sheikh. Uh, may I request him to please uh, share his valuable insight. Dr. Nishat. So it seems that he is busy with some other commitment. So now I would like to introduce our speakers. We have with us eminent speaker from the Institute of National Importance. We have with us Dr. Dinesh Rao. Sir is working as professor head at All India Institute of Medical Sciences, Jammu. He has contributed a lot in the area of forensic investigation. Recently, he had a visit with the uh, Honorable Home Minister Shri Amit Shah, and he has also recently contributed to the National Intelligence Agencies. Sir has contributed a lot in the area of forensic investigation and medical negligence. So we are really privileged to have him on the board. So welcome you, Professor Dr. Dinesh Rao, sir.
Yeah,
Sir,
thank you.
welcome.
Thank you. Yeah.
We also have with us Professor Dr. Krishna Dutt Chabli. Sir has vast experience in this domain. He has worked a lot. He started his journey from the Gujarat and he is working at the All India Institute of Medical Sciences, Raipur. He is the first one who initiated DM in medical toxicology at the AIIMS Raipur, and sir has contributed a lot in the area of medico-legal cases. He written several articles and also has contributed and published books and as a co-author in this regard. So we are really honored to have eminent speaker Dr. Krishna Chabli sir with us on the board. Sir, welcome on this CME, sir. We also have with us Professor Dr. Yes, sir. Yes, sir. Welcome,
Yeah,
sir.
yeah. No, no. Namaste. I was just unmuted just now. Yeah. Thank you so much.
Thank you, sir. We also have with us Professor Dr. Jayanti Yadav. Madam is working in All India Institute of Medical Sciences, Bhopal. She has contributed a lot in the forensic pathology, especially during the COVID time. Madam has done a wonderful job in doing the autopsy in medical legal cases for the COVID cases and contributed a lot. And she has immense contribution in the forensic fraternity in different areas, different fields. So with high regards, we welcome Professor Jayanti Yadav, Madam. Madam, welcome you from the AIIMS Rajkot. So thank you all our eminent speakers. Now without delay, we would like to start our first session with on the topic medical negligence from words I view, and nobody can be better than our eminent speaker, Dr. Dinesh Rao, who is professor head from AIIMS Jammu. So before we begin, I would also like to thank our administration. We have with us our Deputy Director Administration, Dr. Kuldeep GB. We also have with us our uh, previous Dean, Dr. Professor Vivek Kumar Sharma sir from AIIMS Rajkot. So we welcome all our dignitaries and our delegates uh, and welcome to AIIMS Rajkot. So with these words, I would like to uh, convey my gratitude to all eminent speakers, and we should begin with the session. Sir, over to you. Dinesh sir.
Yes, sir.
Over.
Yeah. Yes, I'm audible, sir. Is everything clear now? I think the slide is on.
Sir, you are audible. Slides is not visible, sir.
Slide is audible. I did share. I do it here. Yes, sir. Is it has it been shared now?
Yes, sir. Said just make the presentation mode.
Yes, sir. 1 second. Yeah. Okay, sir.
Yes, perfect, sir.
Yeah. So shall I start, sir?
Please, sir.
We start.
Please, sir. Please proceed, sir.
Yeah. Okay. Thank you, Dr. Sanjay. It was a great introduction, and it was it was nice to hear from all your superiors and seniors and colleagues. Yes, I'm my topic medical negligence, and before I start with the negligence, I would like to give some introduction. As such, we know when we were doing undergraduates or post graduation in any of the specialties, clinical or otherwise, we always hope that treating the patient and the ethical, the Hippocratic oath, what we take, and we know that the patient comes first. This is what we have been taught, and we started treating the patient. But one thing which we never learned, what was that is there are certain legal obligations which we cannot afford to ignore, and there are some legal updates which we never been taught. And seminars like these are the ones which are very essential, because the one which is not being taught at those undergraduate days or during our post-graduation days, but they are playing a lead, or they are playing the lead role when practice is concerned after their so-called specialization or the registered medical practitioners. And they are not only taking the lead role, they're also deciding our credibility in the society. So it is always essential to update these laws. As being a lawyer myself, I've handled hundreds of cases pertaining to medical negligence. And many a times I've seen the anxiety and the anguish and the fear among the medical practitioners. It's not necessarily because they've done a mistake. It is because they are totally ignorant of those laws and the pertinent laws which have been related or surrounding this particular practice. And this is making them more, they're worsening their reputation. So with all those things, I think, and another thing I just wanted to know is, of all the cases of negligence suits filed in India, I think very few has gone for convictions against the doctors, though certain consumer forums did impose certain fines But that is not something which has pulled down the medical fraternity as a whole. It is, I can say, the first victim, though the patient is a complainant, the second victim is a doctor himself. And you know who is the third victim? The third victim are the people who watches those cases, who are never involved, but their anguish and fear is more than the first and the second victim. This is the actual reality of what I've seen. So, during my presentation, I would like to elaborate on what exactly is this negligence, and what makes this negligence, and what are the patient's, what exactly is the patient roles when negligence suit has been filed, and thirdly, what exactly the patient has to prove, what the doctor has to do, and more importantly, what are the defenses the doctor has got, and what are the precautions he is to take. And beside this, what are the legal rights the doctor do have once a case of negligence has been filed. So this is more essential, which many of the doctors, I'm sure, they're totally ignorant about this. But for the fear and anxiety, what I've seen is they never make an attempt to know what exactly are the rights. Though it's a great privilege on the part of them, but they do make an effort to know about it. And above all those things, certain case files, which I would like just the outcome or so-called the rulings with the court has given, and that I would like to just highlight. And then I'll give some few illustrations which I've been involved in those cases. And rest definitely by the end of the session, I'll be happy to take the questions. First, going to my this thing, as you know, what's a negligence? Of course, that's an absence of reasonable degree. See, the reasonable degree of care and skill is that is what when the doctor is treating the patient, what we exert as you know, the responsibilities of the duties of doctors to execute a basic duties to execute a reasonable degree of care and skill. And if there is an absence, the missing factor of care and skill is absent between the doctor and the patient, that will be a great ground for the so-called negligence. Or there is another terminology what we use is willful negligence. That means intentionally, which we hardly see. But definitely a reasonable degree of care and skill, if there is an absence, and more importantly, if this absence of reasonable degree of care and skill that should result in so-called an injury or death of the patient, then only we call it as a negligence. And in a simple terms to say that what exactly is a negligence is that the doctor was supposed to do something, but he failed to do that particular thing. Or he does something which is not supposed to do or which is not expected to do. Then also we call it as a negligence. And of course, as you know, the medical profession between the doctor and the patient has been converted into form of a contract. That is a biggest element or the basic elements in the law of torts. So when the doctor and patient relationship, what we call is as an ethical relationship, the court assumes it as a contract. And that is the reason, being since it has been defined, the relationship has been defined or manipulated in the form of contract in the eyes of law. That is a basic element in the law of tort. That means to say, that means the consumer or the patient himself can claim the damages for any of the deficiency in the contract is concerned that is arising out of the doctor-patient relationship. And what may be the deficiency in the eyes of the court is any shortcoming, any imperfections, or any inadequacies in the services. The services here is the quality and the nature and manner of the treatment or the procedures or the therapy or the surgery or the consultation, any of this. So that is anything arising of the doctor and patient relationship. If there are shortcomings or because it has been gauged as a services, it's a contract. So any of this deficiency, we call it as a deficiency in service for which the patient has got every right to go and claim for the damages that is in the form or may compensate it in the necessary forums. So now the very important thing is what exactly is a negligence. See, the elements of a negligence where it's the duty of the patient to establish that a case of negligence, for him, these four components are very, very essential. Any of those missing components, the patient will be unable to establish his case in the court of law, or the court will never takes the case into cognizance, or the court can dismiss those complaints. So what are those basic things which constitute the so-called negligence suit? The first and the foremost thing is the patient, whoever is complaining against the doctor, the more important thing which has to be present is the duty of care. That means there should be an existing doctor and patient relationship. In the absence of a doctor and patient relationship, the patient, even though he has suffered a damage or an injury, he can never ever go to the court claiming for a compensation or filing a case against the doctor. So this is so important because many of the emergency cases which we handle, it is out of emergency. So that may not come under the purview of so-called doctor-patient relationship or third party, which has referred to you, so-called the formal relationship between the doctor and the patient. That is, when third party are referred to you to examine the patient, doctor-patient relationship is not established, though the doctor has to take all necessary precautions to avoid injuries. So in this case, so that is the reason the existing of doctor and patient relationship is the basic element. And the second thing is, as we know, once a doctor has accepted the patient based on a skill or the knowledge, and he has to deliver the so-called reasonable degree of so-called care and skill pertaining to that particular condition or the disease process. So in this case, if there is any inadequacies or any breach or so-called dereliction in his duty of care, that will be a prime component to establish the case of negligence. And that is followed, that means this dereliction or breach in the so-called care of the doctor, that should have resulted in the so-called injury or the death of the patient. And this injury or the death should be directly related to the so-called the breach or the dereliction of the doctor. That means to say, that is the reason we call it is a direct or proximate cause. So then only if all these four elements are present, there it will be a classic case of negligence. And the very important thing we should all know is despite the fact, if there is a duty of care and there is a breach of so-called the duty of the doctor, but there is no damages in the form of injury or death, then the patient loses his privilege to file a case against the doctor. So always the injury in the physical injury, emotional injury, or so-called any of the things which affect the patient, if there is non-existing or if there is no damage to the patient, no death on the patient, definitely that cannot ever be called as a case of a negligence. Now, again thing is the breach and the thing which we had discussed before. So the another way it's where the court do take cognizance is the acts of commission and the acts of omission. This is very important. It's not only the commission, even the omission. That means when the doctor, what he's supposed to do, he failed to do so. That is, he unjustifiably deviated from so-called accepted practice of the region. There is an accepted practice, there is an accepted procedure, or there is an accepted treatment, but the doctor deviates from those accepted practices. That is an act of omission. But or else in the second category, an act of omission, that he employs the accepted practice, but the way he executes, that will be in an unskilled manner with none of the professional brethren or so-called professional colleagues can afford to do in such unskilled manner. That means an act of omission existing. If any of these two are existing in this way of handling the patient, definitely that will be a breach of standard of care, which can constitute or amounts to so-called negligence. Of course, the court, another thing which, of course, and one thing we should all understand is the court, no, they are not medical personalities. They are not medical men, nor neither the so-called investigating officer. But one thing is a fact. And of course, the patient also can be never be a medical person. But one thing which the court do take cognizance in understanding the case of negligence is so-called the but-for test. The but-for test is nothing mean this. that but for the doctor's intervention, or the but for the doctor's breach in his duties, but for the doctor's breach in his care or skill, but for the inadequacies on the doctor's care or the skill or the treatment or the surgery or the consulting or the advice. If any of this, but for this doctor's unjustifiably deviating from the accepted practice, the patient wouldn't have been injured. This is something which the court can easily understand. Then definitely the court will consider that the possibility of the negligence. And the second factor is, had the doctor not intervened, there wouldn't have been the severity of the not injury wouldn't have been existing. Had the doctor intervened, the severity wouldn't have been there in this particular injury or a treatment or a therapy or a procedure. So since the doctor failed to intervene at the right time, definitely that is the possibility for which the patient has injured or there is a death because the outcome of this particular breach. So that we call it as a but for test, which is very an essential component which the court do take cognizance before awarding the case or a compensation or a so-called punishment. So now we have understood what is negligence and how the court will consider the grounds for negligence. Now the question is, who has to prove this negligence? So it is not the doctor to come forward and say, I did right, and this is what is the standard procedure, and this is what is the method other doctors do follow. This is what I have adopted. So that is not the case as per the eyes of the court is concerned. It is the court to understand that it is the patient, he is the complainant, and it is his duty and it is his responsibility to prove in the court that this doctor has failed to adopt this or comply with those standards, or his treatment is inadequate, or that doctor has breached the care or the skill, or the doctor has failed to comply with the so-called expected reasonable degree of care and skill. So that is what is the most important, and all those responsibilities, and including the basic four elements, that there was an existing doctor-patient relationship, there was a breach, and that breach is directly responsible for the injury or the damage for which he has been claiming. So all this documentation, it is the duty of the patient to establish the case of negligence in the court of law. It is not the doctor who has to establish his intentions or his procedures or his way of practice is not necessary. It is the patient has to establish that there was a case of negligence. So now what actually the decision is made on what? The court usually understand that this particular breach or the absence of so-called reasonable care and skill, that is, if at all, if it is present, that it will be compared with other professional men of similar repute and competence. This is more important. So the court always try to make a comparison that this particular act which has been in the court, or if it's been for which the matter has been an issue or has been complained for, as this particular issue been handled in a similar way with other professional colleagues, or in a way where no colleagues, no professional man of similar repute and competence would have handled. So that is what the court always takes into competence. That is, the reasonable competent medical man would have acted more or less in the same manner in which the doctor whom negligence is alleged have acted. So this is what the court, this is not directly the patient. I've established the case. Yes, trying to prove the case in the court with all those four elements. The court never ever take that into confidence or into cognizance. Rather, the court will always compare with, as this act would have been the same approach by other doctor with similar, with a good repute and competence. Now we understand what is, now let me understand what is this due care means. So due care, it means such reasonable care and attention. That means a reasonable, see, the court has measured the care and skill as reasonable. So reasonable is nothing but the basic things which has been expected in that particular conditions. That is what we call the reasonableness. So which is mean to say that is a minimum thing which any doctor would expect to do so in that particular condition, and that is what we call it as a due care. Standard care. See, standard care, it is the based on the skill and knowledge of the particular practitioner. And this standard of care usually doesn't change from a doctor to doctor, especially at least in that particular region in which he's been practicing. The standard of care so always lies uniform, unlike the degree of care. The degree of competence, it depends on the circumstances. So different circumstances will always warrant a different degree of competence. Whereas the standard of care is more or less uniform. It doesn't even difference between the general practitioner and a specialist. Whereas a reasonable care, we always differ from a specialist and a general medical practitioner. A reasonable care for a specialist will always be more pertinent to his area of practice than a general medical practice. For example, if the person has come with a pain abdomen, vomiting, and an acute abdomen, a general practitioner usually will try to examine the abdomen or do his vitals and try to give at the maximum antispasmodic or an antiemetic, or in case even he can use put some IV fluids and treat and discharge the patient or order for an investigation. Whereas a surgeon, it not only examines, but he always go for invasive or non-invasive diagnostic so that he comes to a conclusion what exactly is the source from which the acute abdomen has originated. And he doesn't stop till there. Besides, he gives the symptomatic treatment. He also try to evaluate the patient condition, the past and the present history. At the same time, he will come out after the investigative techniques or the invasive or non-invasive investigative results. He decides on the next line of management, based on which then he adopts this surgical treatment. Then this, and not only stop till here, even after this surgery, he'll also go for the post-operative and the follow-up. This is what is expected from the so-called specialist. So now I think now we can understand the different approach between a registered medical practitioner and a specialist in one particular case which I have illustrated. So that is where the degree of competence or so-called the reasonable care, what the court do expect. Standard of care, as I said, is superior skill knowledge and the knowledge and the training. That is what is more or less to be uniform, and that standard of care and the skill for any particular condition that should not change. It should be the same care and skill which should have been practiced or accepted in a particular region of practice. The burden of proof, as I said earlier, it lies only on the patient. He has to establish that there is a negligent act on the part of the doctor. And the more important thing is that particular so-called allegations of negligence or the breach in the care that has affected him in the form of psychological or emotional or physical injury, or also it has caused the death of some patient. And that is where the burden of proof lies on the patient. And as I said earlier, if there is no damage or it does not result in death or any damage to the patient, and that cannot be a ground for a case or allegations or filing the case in the court. So other form of deviations, as we agreed, the breach of care and skill. So there is another very important thing which I would like to emphasize is a departure from the normal practice. A patient can file in a court of law that this doctor has done certain procedures which has been deviating, which has not been practiced elsewhere, and that has resulted in some damage. In that case, there is the duty of the patient to first establish in the court what is the usual and normal practice of the region, and then establish that that practice was not adopted. And more importantly, the third aspect is more important, that is he has to establish that this doctor has adopted such a practice which no professional man of ordinary skill would have been practiced in this form. Only then you will be able to successfully establish that this doctor has deviated or departed from the so-called normal practice. And because of this departation from the normal practice, the particular injury or death which he has been trying to establish in the court need to be complied with, or the court has to take cognizance on this. Or else, if any failure in this, he cannot, or his case will be blatantly dismissed. Of course, in 1957, the Boehm's test, of course, which happened in US, and the same thing as even the court of law in India, they do consider, of course, this is an outcome of the so-called the Jacob Matthew case. I think it's the first time in India where the Jacob Matthew case, the court did cognizance of this Boehm's test and gave it a ruling that the professional body of opinions are very important, that are a responsible body of medical professionals. Their opinion is very more important to establish a case of negligence before understanding or awarding a punishment or a sentence. And then came the so-called Bolito's test. Bolito's test is again, though the professional body of opinions was directly the court has taken cognizance, but the court is justified to have a logical basis even on the so-called body of opinions or also on the opinion of any competent doctor, because it can draw its own conclusions on the logical basis of the case. That it means to say it is above the body of the opinions and above the opinions of the doctor. The court do have, that is called, we call it as the Politos. Yes, now the liability. How the court, now we have understood what's negligence and what makes a negligence and what are the due care, standard of care and all this. At the same time, the responsibility of the patient or the plaintiff or the complainant and how he has to establish in the code of law. Now we will understand on what basis do the court awards the so-called compensation or the so-called damages or so-called the punishment. So, as I said, it belongs to the law of torts, as I said, because the doctor and patient relationship has been considered as a contract. The amount of damage, the court do take cognizance before awarding the damage. That is, considering the basis like the loss of earning of the patient. His medical expenses is the most basic thing usually the court takes into cognizance. Besides the earning loss in those period of his hospitality or disability after this discharge, and reduce expectation to the life, another thing which cannot be again gauged. This is not uniform. Anything that can change from case to case, condition to condition, and region to region, and courts to courts. And of course, reduced enjoyment of life, pain and suffering, loss of potency, and any of the aggravation of any suffering or even death. So these are all the things the court do take cognizance before awarding a punishment or a sentence. So this is how the liability is fixed on the so-called medical practitioner. So there is another conditions where, and now I think we have understood that there should be a doctor-patient relationship has to be established. There are conditions where the doctor and patient relationship may not be there directly. That means the doctor has never seen the patient or the doctor has just heard about the patient. Whereas his subordinates or the persons whom are reportable to him, they are handle the patient and there is a breach arising out of their patient care. But you will be surprised to know it is the doctor under whose supervision those doctors were supposed to have been, the patient have been under care. The supervising doctor will be held responsible despite the fact there is a no doctor-patient relationship. So this doctrines, we call it as vicarious liability, or also called as principle of respondent superior. That means to say his subordinates or the persons working under him or the persons whom are reportable him, their mistake, this doctor will be held responsible. This is another very important thing though he was not directly responsible for the patient care, but he will be held responsible under the principle of vicarious responsibility or so-called liability. Many cases, I think I've handled few such cases. So I think if time permits, at the end of the session, I do quote some of the cases with those pertaining to the vicarious liability. Now we have, as I said, of course, there are different negligence. Sorry to mention about that we had so-called civil negligence and criminal negligence, corporate negligence, composite negligence, contributory negligence. So the most important things ignoring about the corporate and so-called contributory, I would like to emphasize on those civil negligence and the criminal negligence. What we discussed earlier is more or less pertaining to the civil negligence or any of the basic negligence. But one very important thing which always haunts the medical practitioner is the criminal negligence, because here it is not only the compensation which has been involved in criminal negligence, the penalization, that means the arrest of the doctor is involved, which none of the doctor would afford to get into this particular part. So that's why the anxiety, fear, or so-called anguish among the doctors are more common, especially any part of negligence. The moment they speak about negligence, they never worry or never hear about so-called civil. They always think about so-called criminal negligence. So, of course, criminal negligence is the danger part. That means to say why danger is because the doctor will be arrested in cases of this nature. So when we say is the criminal negligence, this is something very important. And one thing I would like to say at this, even at this stage, if you go with the statistics in India, out of nearly around until 2000, I think 2021, the number of cases filed of criminal negligence in India is around 1,100. As far as I think I may be wrong in this statistic, but it's approximately around 1,100 cases. But whereas the conviction rates, where the doctor has been sent to prison, it's very, very nominal or negligible, I can say. So that is not much to worry. I will come, I think in the later part of the session, I'll tell you why the doctor should not worry. So, of course, the ignorance make them worry, or failure to understand their rights and legal rights and privileges. That will make them worry. But seminars like this definitely will put their worry at the end. So because that will make them understand what exactly are the legal rights or the pertinent laws which are applicable to them. So criminal negligence, where there is a gross absence of care and skill. Gross absence. Gross is something which is visible. So we say that we use the terminology called gross. And second part is this gross absence of care and skill. Can you imagine? This causes serious, see, this is the terminology which the court says, serious injury, and then followed by so-called death of the patient. So most of the cases of criminal negligence are filed only when the last part, that is when the death has been reported, when the patient died. Always the family members think of filing a case not in the civil court, going to the criminal court, telling that many cases we have seen. And recently a case in Gujarat, I do know, I've heard about it, where they filed a case of murder. So this is how the anguish of the patient, because of the loss, the grief, outcome of the patient, because the loss of the patient, the family members react in such a way that they will not be able to differentiate between a homicide and the death of the patient in the hospital. That is how the case, they directly register a case of murder. And that case, usually they will file so-called criminal negligence. And secondly, when the doctor performs an illegal act, of course, when he performs an illegal act, prima facie, even the investigating officer has a right to file a case. At the same time, the patient family members, their anguish is definitely, it's obvious because of the illegal act. And another instances where we do find is, of course, when an assaulted or when any person, there has been a medical legal case when the person dies, usually to avoid or the shift the responsibility or the onus, then the cases, allegations of criminal negligence, just to deviate the investigating officer and try to come out of those so-called Section 302 allegations, they may file a case. It may be a more or less a conspiratory nature. So, of course, but the criminal negligence will be filed in such cases also. So, as I said earlier, the criminal negligence, gross indifferences, that means the indifferences and the breach is very obvious. It is a prima facie visible. even to a non-expert or even to an ordinary person, extreme departure from the ordinary care, and gross inattention, and more important, that the doctor continued with his so-called therapy or the procedure or the surgery or a treatment, despite the fact he knows that the damage is foreseen. And in this case, even I do never stand with such sort of practitioners where they are a disgrace to the profession. Because with all these things, their gross inattention, their failure or a breach in their care is obvious. And that sort of doctors, definitely. But these are very few. And as far as my knowledge is concerned, we haven't seen such doctors. But such doctors, if at all is there, we should identify those black ships. Now, the question is, what is injury in legally? Of course, not section 44 IPC. That's not we those do and see here. So in a legal sense, as I said earlier, that's prolongedness of illness causing physical harm, bodily impairments, patient death, diminishes the chances of recovery, disfigurement, increased suffering, increased pain, loss of potency, any of these things, that will be glazed as an injury in a legal sense is concerned. So now the question is, now we have understood all those negligence, the patient responsibilities or what he has to establish in the court. The more important thing is why we have been treating the doctor, we have been treating this patient for so many days. So I've seen in the court, the doctor do always try to put his foot. He always contests that I've seen thousands of patients, but never this happened. So why this case, this particular litigation happened? This is something every practitioner need to introspect. The reason being is the breakage in the physician and doctor, that is the doctor-patient relationship, there is a breach. It is not the care and skill, there is a breach. I'm telling you, this is my personal experience I would like to share. Many times what we have seen is, of course, there is no problem with the care and skill. It is the same doctor who has treated hundreds of surgeries, who done hundreds of patients, thousands of patients in his practice. But in this particular case, there is a complaint. Why? Because there is a break in the doctor-patient relationship, and that break in the doctor-patient relationship, what is my personal experience to share, is many a time the doctor didn't give much time with the treatment or with the patient. He never spoke, or he was arrogant. He never answered his calls, and was not punctual in his duty or the rounds. Even when he comes to the round, he spends hardly 2 minutes, but whereas other patient, he spends some 30-40 minutes. I'm telling you, this is the practicality which I've seen with these cases. And the rude behavior of the doctor, arrogancy of the doctor, egos of the practitioners, which cannot become a doctor character. If that has been exhibited with his own patient, the patient will definitely become a litigant. And the most important, the other part is, when the doctor-patient relationship is manipulated in the form of so-called commercialization or marketing way of so-called the fear of the patient has been marketed to extort. If that aspect is there between the doctor and patient relationship, definitely the patient will understand his rights and privileges. He will go and sue to the doctor if there is a deficiency in or injury to him. And he's the last person to ignore or to keep quiet. So because of the complex, invasive and costly procedures which he was forced to spend from his pocket, but the outcome which he was expecting, because he thinks that this costly, invasive and procedures is like an investment for his better health, but that investment has failed. So when the outcome has been least expected or the outcome was very bad, definitely he knows how to take back his investment. That is how he goes to the court to file to doctor. And many a times we have seen they filed a case to teach a lesson to the doctor. This is what we have seen in the cases. And unwanted investigation and less visits, as I pointed earlier. And the second is patient related. Of course, I think because nowadays, as you see, the Google, The patient do come to the doctor after reading in the Google. So he has got certain expectations. He knows what are the investigation here has to be done and what is the type of treatment to be done. I think many of these patients nowadays do understand what treatment, what is the procedure doctors do, and based on it, they inquire or they question the doctors. Which it's a privilege, it's the right to question the doctors. They have a right to information, accessibility, dignity, and privacy. So if this patient more expectations from the doctor is another one. At the same time, they are more aware of their rights and privileges than the doctor himself. This is another surprising thing. The doctor, his rights and privileges is being ignorant nowadays. But what we see is the patient is more ignorant and having his rights, he is more aware of his rights. And more than that, he gets tutored for his rights and privileges. And he tries to go seek a second opinion. And if there is a contrast, there is a difference, definitely. And if that difference is being aggravated by the so-called injury or damage or inadequacies in the care or the breach in the care, definitely that will be a very good ground for him to motivate for the so-called case against the doctor. Of course, the media, as you know, all the good works of the doctors are rarely been coming in the media. It is only the litigations like this are flashed, have been dragged, have been manipulated against the practitioner. That will be more impressive. For example, I think you might have seen in the media where they just announced that so many lakhs or crores have been awarded damages of this particular hospital. But the good work of the hospital never comes in the same media. So this is how there is an encouragement indirectly or directly on the litigation side. So this again for the related. And basically, as myself being a lawyer, also I can say there are young lawyers who are. I think I know thousands of lawyers who are with me, and since I do address the bar councils, they are jobless. And one area they are trying to find the avenues for their job is the medical malpractice. Unlike the Western country, India, the medical malpractice suits filed are negligible. So that is the area they are exploring. I'm confident in the coming years, the cases like these are likely to go high because I personally know, as I said, thousands of lawyers, even my batchmates, we have so many lawyers who are eager to take up this so-called malpractice suits. So attorney related is something mean to say that there is a sect of lawyers who are encouraging malpractice suits. That is another very important factor for cases filed against the doctor. Of course, increased cost of care is something which motivates even an ignorant patient who has lost his money. And even after losing his money, he has lost his family member. So he is the last person to keep quiet and is likely to be a good litigant. Of course, social and consumer rights, after the Consumer Protection Act, after the doctors came under the so-called the purview of being a consumer, and that itself has answered many of those litigants. Yes. So now, what precautions we need to take? It's a very simple thing. See, again, I insist. That is not to fear, absolutely not to fear about the courts or the police or cases of negligence. It's as simple as it is. It's first, do your duty, do with reasonable care and skill. And the degree of care and skill, as I said, depends on the cases. But your care and skill should be reasonable for that particular conditions, therapy, or a procedure which which has been expected for that particular condition. Very simple things. Maintain a good rapport. Have a good rapport with the patient. Try to have a empathizing with the patient. Empathizing with the patient. Treating the patient as you expect yourself to be treated. Treating the patient as you expect your family members to be treated. I think that is the best approach a practitioner should try to adopt in his practice. That's the basic things which I have always advocate. And of course, an informed consent. This is another very important thing. I always say informed written consent more than informed consent, informed written consent. Why informed consent? See, whatever you do, try to explain to the patient, try to explain to their family members, take them into confidence. It is not what you do, what is the outcome of the procedures, what you are doing, outcome of the treatment or the medicines, what you are giving. If there are any side effects, make them understand this is what is the likely outcome of these procedures. This is the possible reactions it's going to cause. And once if this reaction is caused, what you are supposed to do? Call him up immediately. Stop the treatment. This is what is the likely advices. And if this particular procedure, if there are any alternate medicines, if any alternate treatment is there, make a choice for the patient or the family members. And if this alternate treatment or the alternate procedure has got any risk, explain to them. So that means to say, from your side, you have taken the patient and the family member. You explain what you're supposed to do. You also give them the option. What are the other options are there? And what are the risk of those options? So better to go for which options? And more important, if they refuse all these options, what is the risk? If they say, then no, the surgery is important. And if he says, I don't want to surgery, then you should explain to him, refusal of surgery, what will be the issue arising out of it to his health or the body? This we call it as a complete informed consent. Instead, imagine the doctor goes in the morning, he asks his subordinate, a postgraduate or his assistant professor, telling that how many cases are posted today, and he'll say 3 cases, and what are those? And he's never seen the patient. He just goes to the OT and does a surgery, and in the end he realizes he has done something wrong. So now there is no rapport, and the informed consent is absolutely not. That means he has completely deviated from the so-called accepted practice. So this is where the problem lies. So this is what will be a good ground for so-called litigation. And of course, whatever you do, whatever you explain, make a record. I can tell you, I can also advise. It's a legible documents, legible records, something which you can read yourself and recapture once there is a call from the court. And whatever you make a diagnosis, it should be always based on the investigative things. You cannot assume or imagine. It's better your diagnosis is more logical, more rationality is there in this, and more reasonable. So that should be an approach for any clinician for that matter, irrespective of the specialty. And of course, sensitivity tests and consultations, irrespective of the position or the seniority in which you are, it's always certain conditions or certain so-called disease process, they warrant consultations, and that consultations has to be registered. Again, document those consultations and their opinions. That will be a classic defense. I just want to mention again, that will be a classic defense because similar person of similar qualification and experience is having the same opinion as been documented. So that will be a one very important thing always. Apparently, not much people does this because they consider themselves a big senior practitioners. There is no need for them to consult. I think that practice needs to be discouraged. And this another very important, the basic etiquettes. Don't criticize or condemn another doctor. This is not only a bad practice, it is not a good etiquette. So this, and at least not in front of the patient. I mean to see that not in front of, means you can do it in front of other doctor. But I mean to say, never develop this sort of habits. It's not becoming of a good doctor. And again, do not exaggerate or minimize the gravity of the patient condition. Always, as I said, in the informed consent, the condition of the patient has to be explained. And always you should understand that never guarantee a cure. You cannot guarantee a cure. Medical science is not an exact science. I think you all know about the definition. It is you share your skill and experience so that the conditions or the disease in which you can alleviate the sufferings. So this is what will be the way of approach or explanation to the patient. It's not telling that, no, I'm going to treat this. I'm 100%. He'll be coming out. This is not the way. You can just put in another form that I have handled patients like this. There are 1,000 patients like this, and all are with good outcome. And I haven't seen any problem arising out of this particular therapy or a procedure or a surgical technique. So I'm very sure, even in this case, that you'll be out of the so-called the problem or the suffering, and we will do the best. So this is what is the way, I think, the better way or diplomatic way of handling or explaining to the patient. And of course, all of your approach should be rationalized or logical and more reasonable. And yes, once a case of negligence has been filed, so what are the classic defenses? So how can you defend yourself that yes, you're not done wrong? So one is, if there is no duty, if there is no doctor-patient relation, that will be a basic ground. That means you're out of the case at the first stage. If there is a duty, there is a doctor and patient, that means it is your patient, then you have to answer certain things. The first thing is, whatever procedures, whatever duties, whatever therapy or surgical treatment, whatever you're given, you had to establish or convince to the court that this has been discharged according to the prevalent standards or according to the standards or in par with any of the normally accepted practice of that particular region. So this is the type of practice we have been adopted. So that thing you had to establish. And if there is, even after establishing that this was a normal practice, there is an injury or damage, and you had to establish or convince in the court that this particular damage or an injury which the patient has complained, this is arising out of so-called, or it was a risk which was being well known. For example, in one case I would like to establish, a laparoscopic surgeon, a famous laparoscopic surgeon, he has given thousands of laparoscopy. While doing this bile duct, taking out the gallstones and all this bile duct repair, there was a damage to the wall of the duct, and the patient filed a case of damage, what's called negligence against the doctor. But all those treatises or the research or the papers or the normally accepted standard, yes, there are likely to be it was a calculated risk. This damage was a bit, but only problem which the practitioner did was he failed to explain to the patient the possible risk, but definitely he was taken out, that means the court dismissed the charge because this was a calculated risk. And another thing is misadventure. An accident or a disaster which can occur during the course of a therapy or a diagnosis or whatever procedures. So some accident are likely to happen, which is inevitable. It's something which is not in the hands of the doctor. And this is unpreventable. That need to be established. And a mal-occurrence. As such, see, the response of the patient to a particular surgery or a therapy or a treatment cannot be uniform. The response changes from a patient to patient, which has been the literature or a treatise or the practice do confirm this fact. A common example is, I think many of them we have seen that many people may be resistant to amoxicillin. There are certain people who are resistant to amoxicillin, or even gentamicin is well known. Penicillin, I think many do have resistant. Not everybody will have a reaction. So it depends. See, mal occurrence or something which is, and I have seen personally, I've seen a case where for rheumatoid arthritis, rheumatic heart disease, this crystalline penicillin was given, and the patient developed the reaction after fifth dose, and he died. So this is again a mal occurrence. So we have established, and the doctor was out in the case. And of course, contributing negligence, error of judgments, and failure to cure, wrong diagnosis. This is another very important case I can quote. When I was in JIPMA, it happened to the senior most professor in pathology. And a very senior most professor, I don't want to take his name, he was filed a case of negligence because he wrongly diagnosed by reading the slides during his pathological examination. Instead of benign, he labeled it as a malignant. But a case was filed. I'm telling you, a senior most professor in JIPMA. But his slides reading was similar. The opinion and conclusions were drawn from similar senior level pathology professor. And that grounds we had claimed, and he was taken out of the case. That means the case was dismissed based on that. That means to say, if your judgments or if your diagnosis is based on a valid investigations or valid opinions or valid conclusions, definitely you'll be out of so-called. That means error of diagnosis, or failure to cure. Of course, will not be a grounds of negligence. That will be a classic defense, I can say. And contributory negligence, where the negligence is on the part of the patient. So you can claim as a defense, but not necessarily there will be a diminished responsibility. We say there will be some compensation, I've seen the courts been awarding, despite the patient being negligent. Res judicata and indicata, I think you said that means when the case has already been decided, it can be taken in another court. And you have to file the case within 2 years. And if anything going beyond 2 years, unless and until there is a standard or a valid grounds, which usually the court discourages, definitely beyond 2 years, case cannot be filed. So another very important thing in the negligence suits, most especially in the criminal negligence or even the civil negligence, the more important is the duty. See, when there is a procedure and there is some damage is likely to occur, it is the basic duty of the doctor to first anticipate the possible injury or damage like to cause in this procedure or a therapy or a diagnosis. Doctors, the basic duty of that to anticipate such injury or damage likely to cause or arise out of those procedure or the surgery or a diagnosis. Once he not only anticipating, you should recognize during his therapy or a diagnosis or a surgery such complications. And again, it will not stop till here. After recognition, you should take the proper precautions to prevent further damage and the immediate damage. So that if all these things are existing, then irrespective of the damage or not, the doctor can never be alleged or punished, and the patient can never ever establish the negligence even though the damage or the injury is existing. A small simple example, like I can take any injections which cause reactions. The doctor has to first anticipate that in this IV injections what is going, there is a possibility of reactions, and he has to give the IV. During the IV, he has to identify those reactions, intravenous injections, he has to identify. And once the reactions develop, he has to take all the precautions to prevent the damage, at the same time prevent the immediate reactions. If all these things are not existing and the IV injections has been given and the reactions led to anaphylaxis and death, definitely the doctor should never be spared, because I can categorically say he done his job. So this is how the court takes into cognizance. As I said earlier, error of judgment. I don't know how much time I have. If anybody can remind me if the hello? Hello? Yes,
Yes, sir.
how much time I have?
Sir,
Hello?
maybe 5 more minutes, sir.
Oh, okay. 5 more minutes less. Yeah, because we want time for discussion also. Yeah, sir.
Yes, sir. Please.
Yeah, the error of judgment diagnosis, I think I have taken this. And another thing, very important thing, I think we have seen in this practice is unauthorized surgery. Because many a times, I think usually they go over a hysterectomy and they try to excise the appendix, or they try to go total hysterectomy. They try to take off the ovaries, but they want to do just a uterus. They took the ovary also. Means where other unwanted surgery or unrelated surgery, or for the surgery for which it has not been indicated, though they understand during the course it is an incidental decision, incidental discovery, and the decisions are that totally erroneous or so-called emergency decisions without the consent of the patient, despite more important is despite the fact that particular surgery are going to benefit the patient or not. The doctor can be sued for a case of an assault, and this can also be considered as a deficiency of service. Not many doctors know this. Many of the times we have heard the doctor telling, I did the good thing, I didn't charge extra money for that. There was an appendix, it was likely to inflame, and this is likely to cause him more damage, but I took it out. So what was my mistake? It is a mistake, because it is an additional surgery. It's an additional treatment, unwanted surgery. So this is something which we have to understand, that during the course of practice, we have to do what is being required or what has been expected, what has been reasoned or indicated. Of course, the Jacob not much because of the shortage of time, paucity, and I think Jacob Matthew case is a very important case where I said the Boland's test was rightly adopted by the Supreme Court. And more important things, I think the private complaint, any complaint to the police, they can't directly take it. They should be supported by an expert opinion of a doctor, preferably from the government service. And the investigating officer, after accepting the complaint, he has to send the issue or they send the case to a board of so-called experts, maybe a medical association or the medical council. He just refers the cases where they form a board, they examine and they give you opinion. Only if they find that there is a breach, and then only the investigating officer has got a right to proceed against the doctor. This is something which the doctor should understand. Just mere complaint, not to fear, not to worry. There is a lot of procedures coming up. And legal provisions, I think, this is a more important thing I would like to emphasize before we end up, because of the paucity of time. The more important thing is, as we know, because of the BNS and the new changes, there are small changes, but the punishment or the awarding of the punishment or the things are not much difference. Only the numbers have changed. Section 304 can also be culpable homicide not amounting to murder. That also been ordered. Section 302, that is murder cases, have also been filed against the doctors. And commonly thing is 304A, that is rash and negligent act is the commonest thing. And more importantly, rash and negligent act causing injury, that is hurt, that is 337 has become 125A. And 338, that is rash and negligent act causing grievous hurt, that is something which has been applicable to the doctors, even in case of negligence. The other remedies where usually the legal charges applicable, usually they pull the doctor to the consumer court, civil court, and also the state medical board at the council. So these are all the legal provisions. And now this is very important. I would like to spend few minutes on this. If there is a case filed against to the doctor, don't fear, never ever fear, because no police officer can cause or arrest you. Absolutely not. The police officer has to depend on a board of opinion, that is opinion from the body of doctors or group of doctors. Only based on that opinion, if that opinion is contrary to your so-called treatment or a procedure, then only you have to fear. That is number one. And second thing is, if you can also take a legal remedy, go to the High Court and quash the FIR itself. This is something I just want the doctors to understand. Section 482 CRPC, the BNS is also, it remains the 482. Go to the High Court, file a suit and tell that quashing the FIR, because this FIR is damaging his credibility, his reputation in the society, and this is frivolous. So then there is such negligence is never arising out of this particular case. So that option you have. And the most important thing is, the IO is reluctant or is feared to file a case, take a case, is because he knows if he files a false charge of offense by the police, the doctor can file a case against the investigating officer under section 211 BNS. They can file a case against the police himself that a false case he has registered. So that is why the investigating officer will be fearful or scared than you to take cases of negligence cases. And another more important thing is, this happens in Madhya Pradesh and even in Rajasthan, where of course can be everywhere. It is the reason being is the magistrate can summon the police even after the genius of allegations. It can find out and try to scrutinize the investigation and the complaint itself before summoning the doctor. That is under 225 BNSS or 202 CRPC. That means the police officer directly can't file a case and go ahead with the investigation and summon the doctor. The magistrate can summon the police officer and the complainant, study the whole issue, and then if it finds a fact, or there is a prima facie case, or the opinion of the doctor is against this doctor, or the literature is against the type of practice he has done, then only the magistrate. But usually that has not happened so far. That is meant to say, doctors don't fear. There is a big procedure arising out of a mere complaint that should not put you in anxiety or in the anguish or in a fear. That will pull down your rationality, your logical thinking, and you will not be able to present your case. So when you have done no wrong, fear none. Try to defend your treatment or your care, which definitely I'm sure it will always be as per that means reasonable care will be existing and it will be as per the standard because you are already a known practitioner. It's not a first case you will be dealing with. So important rulings, I think since a paucity of time, but I will be very happy to take the questions. So these are all means the important rulings where the court has emphasized that of course the skill of the medical practitioner means it's not uniform to one doctor. There are some changes even as from same specialty. The skill differs. The court has agreed on that. So
Nine.
likewise, there are many things. I know it's because of short of time. And one thing I would like to, yes, in one small illustration in one of the case where the Markandeya Kaju, the Supreme Court, this thing, where overdose of an antibiotic allegations were there. So in that, lost his hearing, and the number of days the antibiotic given, which was in the literature or practiced by others, that was the question. But the court do understand. That is what I would like to emphasize. Court do understand. The court did say that the number of dosages and for the duration of treatment is not uniform. It depends on the type of the condition and the doctor's the type of practice. See, these are the things which the court has taken into cognizance, which we should all understand, not to fear. And that impairment of hearing is also a likely complication which cannot be prevented. So it is something which is again the court has taken into cognizance. And that just because some person has did some mistake elsewhere, the whole medical fraternity could not be blamed. See, again, the court has understood this fact. And more importantly, the court has also understood, despite the best efforts of treatment, the doctor fails. So this is another one. Calculated risk, mal-occurrence, misadventure, all has come in this. That means the court has understood better our practice. That means the court is always with the doctors. So, yes, the appellant was not guilty of medical negligence. Though I mean to say this case, the National Commission has awarded the punishment of damages. That was appealed to the Supreme Court, and the Supreme Court has dismissed the complaint. The whole case was dismissed when the doctor went to the Supreme Court. That means to say, doctors, don't fear, understands your legal rights, understands your legal privileges, and try to participate in seminars like this. And more such seminar, I think Sanjay Gupta has done a great job. I think things like this will enlighten the practitioners and try to imbibe a sense of security and understanding your rights and privileges, in especially the legal rights and privileges. I think that will definitely come into your rescue. Not to fear, do a good ethical practice, and before coming to think, my one statement I always put in most of the forum is one simple thing for the doctors: not to fear the court or the police. They're all with you. The law is with you. That is one to say, the law is with you. Law has never went against the doctors. But only thing is, always adopt, always treat the patient in the way you expect you or your family members to be treated. This should be the approach by the doctors, irrespective of the specialty, once you deal with the patient. And if you adopt this, I am sure no patient will be a litigant and there will be nothing to fear, even if there is a litigation. Thank you, sir.
Thank you, sir. Thank you for such a wonderful, lucid, and informative presentation. As a token of appreciation, we would like to extend our gratitude and a small memento to you, sir.
Okay.
So this is a customized
It's a virtual memento
from AIIMS Rajkot, sir, for you. हम इसको
Okay,
आपके
sir.
पास post करेंगे. We'll send you and we'll ensure that it will reach to you safely.
Excellent,
So-
sir. Thank you. Thank you so much. And I should
Small
thank
gesture
you.
from our end, sir. Thank you so
Thank,
much.
yeah, Dr. Sanjay and his team and AIIMS Rajkot for giving me this opportunity for this celebration. And thank you so much, sir.
Sir, there is one question, and
Yes,
I
sir.
would like to, please, sir. Dr. Ussav, there are certain questions. Dr. Ussav will facilitate, sir.
Sir.
Good afternoon, sir. There is one question from Dr. Chawli, sir. Dr. Chawli, sir, can you unmute yourself and directly ask the question?
Yeah. Thank you so much, Dr. Dinesh. That
Sir,
was
sir.
a comprehensive way of tackling this issue of negligence. Multiple times you said in your talk that you are a lawyer and so for the benefit of those youngsters out there who are hearing you, I would like to know and bar registrations and practice both professions simultaneously.
Correct. Yeah. So yes, I'm a lawyer. I think you heard me right. I am a lawyer, but I'm not an advocate because since I didn't register in the bar council, I cannot be called as an advocate. I'm a lawyer because I've completed my graduation, but didn't stop here. Even before I start with my law practice, because I used to be a consultant to many of the practitioners, especially legal practitioners in Bangalore and Bombay, even in Delhi and even in Punjab and Ludhiana. I have done a lot of cases. So during these cases, I used to give expert opinions, and I used to address the bar council, and that was one when many of the bar council and my colleagues in the law, and they used to encourage me that why should not you do the law? Then I did my law graduation, and after that, as a defense, I think even as a defense, both in forensic cases and in negligence suits, I have drafted many of the things to the consumer courts and many in the civil courts and even in so-called magistrate courts, especially when criminal negligence suits have been filed. So, wherein we have taken all those documents, we have drafted, we have made it a defenses. What are the defenses? And quoting all those treatise and the opinions of the doctors. Thereby, we have handled quite a many cases, quite a many cases. And handling it, it's a passion, I can say. Once you're interested, I think you can find a time. So,
That's
yeah.
that was very informative for the youngsters.
Yes, sir.
So they
Yes, sir. Yes, sir.
also, they will have that if someone wants to do this, they know that they have
Correct.
an venue out there. Thank you.
Yes, sir. Yes, sir. Correct.
Sir, another question for the session is, do court is considering Bolam and Bolitho test both in India?
नहीं bolams have been because bolitos they have not yet. See, we have not reached the stage where bolitos. That means that is the only reason being. See, since with the legal fraternity, I know many judges and practitioners in this field. They have failed to see one thing is a fact. They failed to understand the medical part, especially unlike US and UK. See, in the Caribbean, I was a director and I've handled a lot of. I mean to say forensic cases with the US government, US courts. They are very good with the medical side, means they have a very good knowledge. Whereas unlike in India, so we have the so-called the comprehension of medical side or understanding the medical case, let it be a forensic or a medical cases. It's very less. They all depend on another medical fraternity to make them, to apprise them on certain cases. So this is the reason the bolitos have not taken it. Bolitos where the judge has to go beyond bolams. That means to say that beyond that his conclusion should be more logical, that it is more logical for him to conclude. You should understand the body of opinion given by the professionals are inadequate or shortcoming, or it is not pertinent to that case. For him to come to that conclusion, he should have understood the medical science far better than the so-called the board of doctors. So that is the one constraint. I don't know in the future days or the future years when young judges have come who have got a good knowledge, they may take on the bolitos. But Boland's test, luckily after the Jacobs case, it has come into the front and they are considering, and that is a very good thing which has helped the doctors. Because earlier I think you might have heard that direct complaint, the police used to rush and try to get into the doctor's clinic or a chamber and take him to the police. But even now the Supreme Court has said 154 CRPC, where when the FIR has been filed, the court can summon the doctor only in case the evidence is required to collect the evidence from the doctor. Arresting and all is not required until there is a solid case. Despite this, Supreme Court, many cases, I think in one of the courts I just wanted to mention, even though prima facie case, even though res ipsa laquata, that is another doctrine where the thing speaks to itself, even though there is a damage, it's all visible, despite the fact, the court will never come to the conclusion there is a breach of duty. It will always rely on the opinion of the other doctors. And it not only opinion of other doctors, it also should be corroborated with the treatise or with some books which has to quote with the similar opinions of the body of opinions of the doctors. This is how it takes into cognizance. That's why the bolithos have not been taken into cognizance, sir, for the moment. Yeah.
So thank you, sir. Thank you for such a informative and useful session for all those who are attending this session through the Zoom Eco platform and through YouTube channel. Thanks once again. You have clarified aptly that there are certain gray areas, but this is the topic which is really important and useful for the all practitioners and all faculty in this fraternity. Thank you, sir. Thank you once
Thank you,
again.
sir. Thank you. Thank you so much. Thank you so much. Yeah.
Thank you, sir. Now we are moving toward the next session. We have with us eminent speaker Dr. Krishna Chavali. Sir is Professor Head at All India Institute of Medical Sciences, Rajpur, also Dean Student Welfare. Sir is going to throw the insight on pulse and pitfall in management of medico-legal cases. This is the area where Sir is contributing a lot. He has already published paper in this area, and if there are queries related to the medico-legal cases in any context, we can discuss and share through the chat box, and the queries will be taken at the end of the session. So over to you, sir. Thank you, sir. Sir, please unmute yourself.
Yeah.
Yes, sir.
Thank you so much, Dr. Sanjay. And if I can be made a co-host, I can share my presentation.
Sir, थोड़ा voice
So,
जो है
already made you the cross, sir.
Sir, you are already co-author.
Okay. Then I'll just share it straight away. It's already
Your
been.
desktop is on the screen.
Yeah, sure. I'll do that. Yeah. Please let me know if I can, if it is visible.
सर थोड़ा वॉइस आपका जो है वो लाउड हो रहा है अगर इफ दी
Want to
some audio setting can be little
just
bit.
one. I'll do that.
Yes, sir.
Yeah.
Now it's fine, sir.
Yeah. Can you just tell me if my slides are visible?
Yes, sir.
Okay. So I'll go to the presentation mode.
Yes, sir.
Okay. So this topic I have been asked to speak on pearls, and pitfalls in management of medico-legal cases. So I am Dr. Krishna Chavali. I am Professor and Head Forensic Medicine and Toxicology and at the All India Institute of Medical Sciences, Raipur. I would say my qualification for talking on this topic is that I come from a place which was newly established when I joined this institute, and having had that advantage of starting my department from the scratch, I could do it in the way that I envisioned the department to work. So in that process, we started with the forensic medicine unit in our department. Our clinical forensic medicine unit, which is, I must appreciate the support of all our faculty members, our residents who work 24 hours a day, 365 days of the year, and we manage all the medico-legal cases that are presented to the institute. So this is our achievement here, I would say. And this we do not limit it to only those cases where forensic examination is required. In any medico-legal case, any clinician is free to ask us for help, and we give them advice, and we help them, we support them to the extent that even when it comes to going to courts, it is because we, being the first responder in the hospital, it is us who go to courts and the clinicians are spared. So with that introduction, I would like to talk on this topic. The stage.
Sir, pardon me for 1 minute.
Yeah.
You have to share your presentation mode rather than
Yeah,
the PPT.
I've done that. I have not changed the slide yet. If you want to just see whether it works or not, I'm doing this. so that you know it works. Just 1 minute.
Okay, sir.
Okay, done.
No, sir. Still, it's in a PPT mode.
No, but it's feeling for me. Just 1 minute. I'll do one thing.
Just reshare once.
Yeah, I'll share the entire desktop so that it should work. That trick sometimes works.
Okay, sir. Okay, please proceed.
Just 1 minute. Just 1 minute. Yeah, this is a problem. I know it happens multiple times. I'll do the screen sharing. Okay. And then I share. Okay. And now, please let me know if it works now. Is it working now?
Absolutely right, sir.
Right.
Perfect.
Thank you. Okay. So, where was I? Yeah. This is a topic which is, I'm not talking about something new. It's old wine in new bottles. So I don't claim to add something to what you already know. Just a refresher. You can take it as a refresher sort of talk. And I'll try to be brief. I'll try to be as quick as possible so that the next speaker gets adequate time to speak on their topics. So just as the stage has been set by Dr. Dinesh Rao, and talking about negligence and medico-legal cases and police, courts, arrests and punishments. Towards the end, however, he was very clear that the law is in favor of doctors. But still, despite everything, the fact is that when a doctor talks about a medico-legal case, it's like you may like it or you may hate it. But the fact is you cannot ignore it. It's part and parcel of your medical practice. You cannot have a medical practice without having a medico-legal case. So, so this is, I think, the line that every doctor should understand before he joins. I tell my students, the only way you can avoid medico-legal cases is to stop practicing medicine. And that's the only way. There's no other way out. So it is better that we acquaint ourselves with medico-legal cases and medico-legal case managements so that we are well equipped to handle it whenever we encounter one. So medico-legal cases comes to you in 3 situations. Both the emergency cases, emergency managements, elective cases where the cases present in the OPD, or sometimes they just come for medico-legal purpose only, legal purpose only. So the idea of putting this slide is to tell the audience that you can't escape. You can't say, I'll go to dermatology so that I won't get a medico-legal case. Interestingly, that is, dermatology is one field where the highest compensation so far in consumer cases has been awarded in India. So, so you can encounter medico-legal cases in any situation. So again, I would like to just reinforce, it's better to know and acquaint yourself than avoid medico-legal cases and medico-legal situations. So I'll not be theoretical. I'll go by a practical thing. Maybe it's more interactive. I would like people to interact, but I don't know whether it would work or not. I'll go by a situation wise. You are not in a mood to examine patients today, and you refuse to examine few patients. Now, this is, I'm talking about your right to choose a patient. Is this acceptable? Can you accept patients just because you don't want to? So this, whatever I'm talking about, this is more about clinical practice rather than I'm talking about frank forensic medico-legal cases. So in clinical, so this should apply to a wider audience than only forensic people. So can you apply the principle of your right to choose patient in medico-legal cases? Is it acceptable? No. If it is a self-employed situation where you are sitting in your own clinic it's acceptable. You can shut shop whenever you want. You can open it as per your moods and as per your convenience. But if you are in an employment setup, you are on a contract of employment with either the government or an agency or a corporate hospital, you don't have such right. And emergency situations, again, you have no such right. You if it's a situation where many persons, many doctors know this and they avail the concessions offered by Indian Railways, by the airlines, where you have to just give them a copy of your registration certificate and you get some concession in your ticket fare. Now, having said that, you have to understand that you are actually agreeing with the concerned agency that you would help them in case of a medical situation, medical emergency situation while on the journey. So you cannot hide when such a case is presented. This is an emergency situation, and the case is presented to you. You are asked, doctor, now come please and help this passenger who needs medical attention. That's an emergency situation. You can't say no. I don't have it. I am not doctor. I'm not in my clinic. I can't help. So similarly, medico-legal situations also you cannot refuse. Medico-legal situations are more importantly when you refuse, you risk uh, cancellation of your registration because you are not doing something that you have to do as a duty towards the state. Another situation I would talk about, I'll go step by step. I'm talking about now, having considered the fact that whether you can choose patients or not. Now we'll talk about consents. A patient is received in the emergency. It's a case of a road traffic accident, and the people who have been passing by the accident site, they out of kindness brought him to the hospital. Patient is unconscious and requires a life-saving procedure. Now, whose consent should be taken? Can anyone guess and tell me? Yeah, I'll just tell you. It's in such a situation where it's a life-saving procedure, there is no need to take consents. Section 30 of the BNS says that any act done in the good faith for the benefit of a person without consent is not an offense. So I'm actually, repeating what Dr. Dinesh Rao has said, law is with the doctors. If you're doing something for the benefit of a person in good faith, and where a situation is such that consent cannot be taken or the person is not in a position to give consent, then the procedure can be done without consent, and that is what law tells you, and you get that benefit. Now, so what is the age when a person is eligible to give consent? It's very simple. Again, just a refresher again. Like I said, Section 25 and 27 of the BNS, which say that act intended, not intended, or not known to be likely to cause death or grievous hurt, done by consent of a person more than 18 years is not an offense. And similarly, 27 says act done in good faith for the benefit of a person less than 12 years, or person of unsound mind or by consent or consent of guardian is again not an offense. So that means indirectly law tells you that a person above the age of 12 years can give consent for anything which is not, here we are talking about likely to cause death or grievous hurt. And 25 is you need a person to be more than 18 years of age to give consent for something which is likely to cause death or grievous hurt. So this is the age for consent. Medico-legal examinations also, I would say, many times is not anything that would cause death or grievous hurt, but especially in cases of sexual offenses, where a case of POXO is presented to the hospital. Many times I have seen doctors who say that because I'm not doing any invasive procedure, the consent of the survivor who is 15 or 16 or 17 is sufficient, and I do not need to take the consent of the parent or the guardian. This is wrong. I don't know if I am wrong, you can please correct me. But I think a child less than 18 has no right. He or she cannot give consent, valid consent. So a survivor of rape or POXO survivor cannot give valid consent for examination, which includes inspection and maybe even introduction of an instrument or a finger into the vaginal canal, so that could itself amount to an offense of rape. So it's better to take the consent of the parent or the guardian in addition to the child's consent in such cases. So what are the precautions that you would take with consent? Would you take consent of the person or the next of kin? So in India, it's very common. We uh, openly talk to people, whoever accompanies the patient, without bothering about who that person is, whether he is the next of kin or not. Even if he is the next of kin, whether we should be talking to the person or not. Technically, you cannot take consent from anyone other than the patient himself or herself. So this is something we ignore, and we take consent of anyone who is present, and that can lead to a big issue. And we have multiple court cases where consents of people other than the patient were taken for surgeries, and post-surgery cases have been filed against the doctors, and they have been won. The doctors have had to pay a huge penalty for such operations without consent of the patient. So we forget the basic tenet of medical ethics, which is autonomy. Autonomy, one of the basic tenets of medical ethics, is ignored in India. And that is where, when in case of problems, when in case of doubts, in case of an issue, when matters go to court, then these sort of consents are invalid consents. So please, we should be taking care of such consents. So next of kin is a strict no. Sometimes you might argue that the patient is unconscious and we cannot take consent. So in that situation, you ask yourself whether what you're doing is life-saving. Go ahead, do it. If it is not, you can wait. If you want to, inform, there are relatives, you can just inform them. You are not taking their consent. You are taking the decision, but you are informing them that this is what has been done in good faith for the benefit of the patient. And go ahead, document what you have done, document why you have done, and that should protect you in case the patient or the relatives prefer to file a complaint against you. Just 1 minute. Yeah. If illiterate, we have cases of whether you should take the left thumb impression or the right thumb impression. I'm of the opinion you can take any of the 10 fingers. Doesn't matter. It is just arbitrary. It's just for an identification process. It could be your left little finger as well. I don't mind. But nowadays you have a phone. Everyone carries a phone with you. You can take a video consent if the person is illiterate, if you can speak to the person, and if the person can respond to your questions, that can be video recorded, and consents can be taken on video, and a note of that made on the case file. The recorded consent will have to be saved somewhere for future use if at all it is required in the future. Name of the patient and witness with the procedure. Now, consents, usually, if you look at consents in the case files of the hospitals, you will find that consents bear only the signature of the patient and nothing else. Now, that is very wrong. A consent is an agreement between the patient and the doctor, and that has to be witnessed also. So It has to bear the signatures of at least three persons, but ideally four people: the patient, the doctor, and two witnesses. So this is, and the entire procedure has to be outlined. Now the question that would come up is, now what do these witnesses do? What are we breaching confidentiality if we are bringing in witnesses who are unrelated third-party witnesses in the presence of whom we take consent, we explain things to the patient, and then we ask them to sign? That's a wrong concept. What I interpret this as, the witnesses are witness to signature. They are not witness to the consent procedure. So you can take the consent, and and this applies only to written consents, by the way, or to verbal consents. If you're doing a video recording, I don't think a witness is required. But in written consents, you can the witness comes into picture. They are called in to sign when the doctor and the patient are about to put their signature. So they need not know what has transpired between the two parties. They are just witness to the signature and not to the consent procedure or the consent content. Now, a situation where you receive a person in the emergency brought by the police for force feeding. He has been on a hunger strike. The patient is conscious and expressly refuses any intervention. Will you comply with the police request? He is conscious. He is refusing. He's saying, don't touch me. I don't want any intervention. I am sitting on a strike and I will not budge till my demands are met. Now, what do you do? The police has brought him for force feeding because they know that if something happens to him, then there will be huge trouble. So what should you do as a doctor? As a doctor, this also is a medico-legal situation for us. We will not comply with the police request because the person is conscious. He is in a situation where he can decide for himself. Again, a question of autonomy. The person is fully aware of what he is going through and what can happen to him if he refuses intervention, and he is denying it. So he has not given you a consent, and you cannot force. That would be an assault. If you force feed him, he can complain against you. He can go to court against you, and you can be tried for assault on the person without his consent. So we should be very careful. Just because the police has requested, we should not be doing this. So that comes to the question of what is informed refusal. So there's nothing like an informed refusal. We have heard about informed consents. Consents, yes, inform and then you consent. And after information, if the person refuses to give consent, a term which has been coined, I think, in the Indian scenarios only. I have not heard of this term outside in Western literature. But informed refusal is more of, you have informed the person of all the nitty-gritties of what is suffering from, what is the disease, what are the options available, and what would be the pros and cons of the person accepting or refusing a particular line of treatment. That is an informed refusal. And then he refuses. That would be a informed refusal. So does it apply in life-saving measures? A person might need to be put on a ventilator. Do you think we can resort to informed refusal? This is what happens. The relatives are adamant. We do not want our family member to be put on a ventilator. So they say, please don't do that, and we are taking the person away. Should you do it? Should you comply with their request? I think no. If you think that the person has a good chance of survival, and if you think that this is the only way that you can save him, you should go ahead and just inform the relative that we have done this, and that's all. Let them agitate. If they're agitating, you can call in the police. You can ask them to go to the court. You can say you can go and file a complaint against me to the courts. It's okay because I have done what is best in the best interest of the patient. So we should not be going for informed refusals in such cases. Uh, Victims of rape, sometimes, when they are brought to the hospital, and they see that the doctor is a male person, and they might say, we do not want to be examined by this person. And they are right in their way. Here we have to, we have to allow such a request, and we take it in writing from such person that the person is not willing to be examined by me, the lone doctor, who is a male doctor, and there is no female doctor available, and so I am unable to examine this person. Okay, so this can happen sometimes. Sometimes we have had cases where especially in POXO cases, where the child has been missing, the parents have lodged a missing child complaint, and when the child is found, they raise a doubt whether she has been sexually violated, and the police bring the child to the hospital. When we explain to the parent that this is the examination that we'll be doing, and the child and the parent both, they have refused. The child, maybe I use the word child, but she is 17, and she refuses. She says, I'm not willing to undergo the examination. The parent also says, no, I do not have such a doubt. I thought it would just be a matter of verbal questioning interview, and that's all. So we are not interested. We have taken it in writing from both the survivor and the mother that they are not interested, and we have not done the examination. In fact, we have also gone to court in that case, and we have told the court we have examined because they have refused it to be examined, and the court has accepted our statement. They said, very good. If they have given in writing not to be examined, and no one can force them. So this is also a situation where you might need to go for an informed refusal. Similarly, you have something called as discharge against medical advice, or more appropriately, we should say leaving against medical advice. So when a person wants to leave the hospital against medical advice, and you know that the person needs medical attention, and then you tell them that you explain to them all the pros and cons of leaving the hospital at that.
इंडिकेट किया है बोला है तो मैं कहा कि ठीक है मैं जब करता हूँ
Someone is talking. Can you please mute yourself? Okay, so they do not wish to continue with treatment. Yes, you can't force anyone to have to take treatment, but if the person has any damage subsequently, it would be your liability. So it is better that you take a informed refusal from such a patient or the next of kin that they would like to take. Like I said, a person on ventilator, they will say, we want to take the person to some other hospital, and you think that shifting the person would be a risk. We usually tell them to get an order from the magistrate. Let the magistrate order me, and then we can send the patient. Otherwise, we won't. Or we say you arrange for a ambulance with a ventilator facility, and we make sure that the hospital where they are taking is aware that this patient is being brought, and they convey that yes, there is a vacant ventilator bed available where this person can be accommodated. Only then the person is allowed to go. So here again, an informed refusal to continue with treatment would help us doctors to save our skin. Okay. Another situation. Right. Okay. Another situation is that you receive a case in the emergency, which is a potentially medico-legal case and needs immediate care to save life. So it's a head injury, and the person has to have an urgent craniotomy. And can you start treatment or wait for the police to arrive? Not a very big question. It's no big deal for all of us. We know that we should immediately start treatment. The first priority is to save the life of the patient. All legal formalities stand suspended till this is achieved. This is not said by me. It is by the Honorable Supreme Court of India in one of the cases, Parmanand Katara versus Union of India, which is an apex, which is a very important case as far as medico-legal case management is concerned. So what is a medico-legal case? A medico-legal case is a medical case with legal implications or a legal case with which requires medical expertise. So the who would so the next question is who would decide whether a case is medico-legal or not? So a situation is a person is brought to the emergency with a history of a dog bite. Should you register this as a medico-legal case? Who decides whether this case is to be registered as a medico-legal case? Now, this is a tricky question. Every people might say a dog bite would not be medico-legal case. And in that case, I would carry the argument further. I would say, what about snake bite then? So dog bite causes rabies, and rabies is 100% fatal. Snake bite, even there's a chance of survival. So why do we register snake bite as medico-legal cases and not dog bites? In fact, in our place at our hospital, we have stopped registering snake bites as medico-legal as well. We do not, unless the person dies. So here the thing that I ask people to take care is, what is the story? What is the person complaining about? The story is that it's a street dog which has attacked him, and then it could be, and he is not in a position to, he has just come for the first time in this area, and he has been bitten by a street dog, and he is only worried about his health and not about the dog. So you can just treat him as a non-MLC or a non-medical legal case, and if he says it's my neighbor's dog, which never leaves the dog on a leash, and he goes for a walk with the dog freely walking by him without him on a leash, and then that dog bit me. Now this is a potential medical legal case. He is indicating that the dog is now used as a weapon of offense. So now it ceases to be a dog bite. It now becomes a case of assault. So then it becomes a medical legal case. So you have to understand the situation. The same dog bite could be medical legal or otherwise. Even sometimes it could be a street dog, and he says, and he's very agitated, saying that I have complained multiple times to the municipal corporation authorities. They have not taken action against the dog menace. They're multiplying like anything, and we cannot get out of our houses in the night. And this is what has happened. He's agitated, very clear. So better to make it medical legal, so that if he goes to court, if he complains, before that you have already informed the police that this person has come to us, so the police can help him out with his filing of the complaint. So the understatement here is that the registered medical practitioner who is examining the patient is authorized, is empowered to label a case as medico-legal. So if the doctor feels that a particular case is not medico-legal, he can simply not register medico-legal cases against everyone. So having a blanket rule of registering a medico-legal case against any case of injury or any case of poisoning would be wrong in many cases. A child might have accidentally swallowed a tablet of aspirin or paracetamol. Technically, that amounts to poisoning, a case of poisoning. But I would say, okay, it's okay, fine. Or for that matter, let us take it as a tablet of diazepam. I would say the child would sleep, that's all. But it's not life-threatening. Let us wait, let the child come out of that drowsy state, and then you can take him home. That's all. But we do not want to make it medico legal. Children play in school, they fall down, they fracture their limbs. We don't make them medico legal cases just because there's an injury. So it is the doctor who decides whether it is a medico legal case or not. So now once a case has been admitted as a routine case, then after some time, So you have admitted you have not made it medico-legal. You have followed my advice, the last slide, and you said, okay, Dr. Chavli has said don't make it medico-legal. I admit it as a non-medico legal case. Now, after 3 days, the person comes up with another story where a foul play is indicated, or the circumstances suggest that foul play is suspected. Because at the time of admission you had not informed the police, should you inform now? That is the question. Will you be in trouble if you inform now and the police ask you, why did you not inform us when 3 days ago when he was admitted? So documentation is the answer to this. Document everything. Document on the file that this is the new fresh information or fresh circumstances that have come to our knowledge, and that is the reason why we are making it medico-legal now. So now you are making it medico-legal, immediately you send an intimation to the police. So you will inform the police, and if the police uh, say that ask you for justification, you can tell that you are not at fault, there is nothing to fear, and you can just tell them that this information was not available at the time of admission, which is now available, and hence this case is now being made medico-legal and intimation being sent to the police. One more situation. Now the person who was admitted as a medico-legal case dies under treatment, but the relatives do not want a post-mortem examination. A very common situation. People do not want to get the bodies of their next of kin autopsied. They think it's a lot of mutilation, lot of damage. So what should you do? Do nothing. It's very simple. You are no one to decide whether an autopsy is to be done or not. It would be the police. Section 194 BNSS tells you that it is the investigating officer who decides whether an autopsy is to be conducted or not. You just have to inform the police. You can inform, if the police are convinced that an autopsy is not required, let them give it to you in writing. And we say, fine, we hand over the body without autopsies. And we have done that here. In Raipur, we have started this trend where we have told the police about their powers, about their rights. And now that they are convinced, now routinely police, we inform the police in cases brought dead to the hospital. The police investigate and they tell us, give us in writing that we do not find anything foul in this case, and you can hand over the body to the relatives without an autopsy. And we're doing that. So our job is to preserve the body and to inform the police. Let the police take the law into their hands. Let them decide what to do with the body. A case just opposite of what we discussed just now, a patient under treatment, not a medico-legal case, dies unexpectedly, and the treating medical practitioner wants to get an autopsy done to find the cause of death. So this is, we all know it's a pathological autopsy, and there we would like to take consent from the next of kin, which is very, very important. And in this case, even a consent for partial autopsy has to be respected. The relatives might be interested in only allowing you to open the abdomen. They would say, please don't open the chest and the head, and you have to agree to that. So you should respect that consent. You cannot say we need to do a full autopsy on this body. And the pathology people can help you out with the autopsy. If not, we are always there. Now, same way you receive a patient in the emergency, you find him dead, broad dead case. Can you issue a cause of death certificate in this case? Can you issue a cause of death and then pass it off as a non-medico legal case? Or is it a blanket rule that every case brought dead to the hospital has to be made medico legal? Now, this is something which is very tricky, but many times being in a tertiary care hospital, we find the patients who are taking daycare treatment for oncological conditions, they very frequently are brought to the hospital in a unresponsive state. And when we examine that person, we find the person is dead. So we call, we ask the relatives whether whether the person has been receiving treatment from our hospital, and if they produce documents in support of their claim, we call the concerned clinician, who would then opine whether he or she would be comfortable giving a cause of death, an MCCD. And if he is comfortable, then we ask him to do that, and the body is handed over to the next of kin without an autopsy as a non-medical legal case. However, if the no such documents are available, if it is a hospital outside the hospital, and we have convincing documents which tell us that this person would have died anyway, we keep a copy of the documents, and we make it we issue a medico legal a MCCD, medical cause of certificate of cause of death, and in form 4A, and we hand over to the boy to the next of kin, while retaining a copy of the treatment records of the person who might have been availing treatment from somewhere other than our institute. Otherwise, if none of these is possible, we are helpless. We inform the police, we tell the relatives that this is now beyond our means, and you can go and convince the police. And if they are convinced, we have no objection. Now, again, I just talked about this matter, so I won't repeat again. But a patient of poisoning arrives at a hospital. Should you inform the police? I have just talked about that. Older books especially, have given something like this. If it is homicide, you inform. If it is suicidal or accidental, you don't. If it is a mass accident, you inform. And government setups, you inform all cases. So this is what has been given in books. And those of us who have been using or who still use older editions, I think that this is wrong. If it is a case of frank poisoning, I think it should be informed. Other than an accidental thing like a child, like I just said, a child who has accidentally, and you're convinced that it's an accidental thing and not intentional, then you can wait. You need not inform. But in all other cases, including suicide, because there's a misconception that in the Mental Health Care Act, Section 115 says that person who has committed suicide should not be prosecuted legally, and so these cease to be medical legal cases. No, I am of the opinion. My idea is that we should inform the police, let the police investigate, let them find out what led the person to commit suicide or attempt suicide. And if they are convinced that it's because of mental ill health, then only it ceases to be a medical legal case. No prosecution is done in the courts. Otherwise, if someone else has forced him to or has driven him to that state where he had to commit suicide, then naturally that person will be tried for abetment. So from our side, from the medical side, we should inform the police of such cases as well. Medical legal cases handling usually is because of people they need they intend to get a medical legal report. So they think that you just go to the hospital, you are examined, a report is prepared, you take that report, and then you can go to the court. It doesn't happen that way. Medical legal reports are prepared by the doctor for the use of the courts, for the use of the investigating officer, and then subsequently to the courts. So the original report always goes to the court. It does not go to the relatives or the next of kin. And a copy, even if you have to give a copy to the relatives, it has to be, except in the case of a survivor of rape, where a copy has to be given to the survivor immediately after examination. In other cases, copies should not be given, and they should be the relatives or the patient should be asked to get NOC, the no objection certificate from the police or the court, for so that we can give them copies of the report. As far as original case file of an admitted patient is concerned, even if it is a medico-legal case, if the patient or the relatives ask for the original case file, I think we should comply, because the case file, the patient is entitled to ask for a copy of the page of the case file. You don't give it automatically on discharge. When the person is being discharged, you automatically give him the discharge summary, but you do not give him the entire case file. But if they ask you for the entire case file, that has to be, you have to give photocopies, and you have to comply the request within 72 hours of receipt of that request, and the photocopying charges will be borne by the patient. They will not be free of cost, because that would be a extra burden on the hospital. Moreover, if you do it free of cost, everyone will now ask for the files, and then you will be wasting your time copying all the case files. Similarly, you ask for original X-ray film, CT scans, flights. What should you do? The question that you should answer, you should ask yourself, is who paid for these things? Because even today, in government hospitals as well, most of the investigations have become paid investigation. They are not free of cost. So if the patient has paid for the investigations, and the X-rays or the CT scans have been taken, when the patient has paid for it, the films rightfully belong to the patient. You cannot deny. In fact, it's the other way around. You have to request the patient to keep a copy if you wish, to keep the original if you wish, if you have not made a copy. Otherwise, it would always be advisable in medico-legal circumstances to ask your radiology department to take 2 copies of the films. Nowadays, we don't need 2 exposures. You just need to take 2 prints. Even now, we have handheld X-ray cameras, X-ray machines the size of a DSLR camera, and you get a digital image on your screen almost instantly. You can save it, and you can give a printout to the police if they need, or to the patient if they need. And that digital X-ray or a CT can be used for your records as well. So you can't refuse the original films if the patient has paid for them. However, sometimes the person is brought by the police to the hospital, say, for example, a DNA examination, and the police brings the person for DNA examination, and the patient is not paying for it. So in this case, the person might say that this is my DNA, I have a right to the report, but no, till the court does not allow it, we do not give the copy of that report to the patient or to the person. It goes to the court, and the court will decide whether to share it with the person or not. Another situation I would like to share. This is about again medico-legal cases, change of patient particulars in the records after discharge. Should you do it or not? Many times, yes, it happens. A person is brought in an unconscious state. Someone accompanying the patient gives some name by which he is known in the locality, and treatment is done. And when he is discharged, he finds that the certificate, the discharge summary, bears that name, which cannot be now produced in his college, school, or office. So he requests that it be changed. Okay, so you might consider such a request. But the thing to be borne in mind is you have to have a written application with an affidavit to the effect that this person is the same. It will have you'll have a photo ID cards annexed with the affidavit, with the application, and that has to be approved by the hospital committee. So the hospital should have a policy before such applications are received, and those only that hospital committee will go through this. Why I put emphasis on this hospital committee is because we had a case recently here where a person who died in the hospital during treatment, and the discharge summary was given to him, and everything was done. Now the person's son comes to the hospital and tells us that this person was actually known by another name, and believe it or not, that was a Muslim name. So it was a totally different religion. So he said he was known by this name, and he wanted the certificate, the death certificate in that name. So now he has a death certificate in the Hindu name, the current name with which he was admitted, and now he wants another certificate in the other name which he was known. So on interviewing that son, what we got to know was that this person was a railway employee who was drawing pension from his previous job. He then came to this place and he started working in some government office here again under a different name. That means he has changed his identity, and now he is working here. And now the son wants to draw pension from family pension from both the places. So you have to be very, very careful in such cases. So a committee would always, one brain may make mistakes. Two brains or three brains is always better. So go for a hospital committee for approving such cases. Now, you prescribe a drug to a patient and illegible handwritings. We are very famous. Doctors and illegible handwritings go hand in hand. And, the pharmacist gives something else because he is not able to read what you have written, and the patient suffers damage. Who is at fault? Should the doctor be punished? Should the pharmacist be punished? The answer is both of them are at fault. The doctor for having not given the prescription in capital letters, in a illegible handwriting, or not in a generic form, and the pharmacist for not confirming with the doctor when he was not able to read that and having given whatever he could understand, make out of that handwriting. So both of them are at fault, and both of them are equally at fault and can be punished. Now, few medico-legal situations, not exactly medico-legal cases, but medico-legal situations also that can arise by, say, for example, mandatory HIV, HBsAg testing prior to operative procedures. This is something which I have picked because this is now routinely being done. Now, this does not guarantee, a negative report does not guarantee that the person is not infective. So there is no point going for this mandatory testing. It is not to be done. If you still want to get it done after consent, after pre and post test counseling only. Only then, after counseling, after consent, only then you can get the testing done. If the person refuses after counseling, still would you go ahead with the procedure that he has come for? You have to. You cannot refuse, because that would be a crime. It would be differentiation. You are again breaching one more rule of medical ethics. So you can't refuse. You have to go ahead. If it is an emergency, all the more important. You can definitely not refuse. So you have to take precautions in all cases. Take every case as a potentially infective case and handle it that way, rather than asking the patient to get testing done, which would be, it could be misleading, and the doctor can go into a complacent state. Patient wants to leave against medical advice and ask for discharge summary as well as ambulance facility to go home. Can you entertain that? So he has irritated you enough. He wants to go home. You try to convince him. He says, no, I don't want any treatment. I'll go home. And he says, I want a discharge summary. Should you give him a discharge summary? Many hospitals say, because he's going without my advice, I won't give him anything, let him go and suffer whatever damage he suffers. But that is not legally tenable. Legally, if you do not give him a discharge summary, you are negligent. Courts have found doctors to be negligent when they have not issued or they have not given discharge summaries to patients leaving hospitals against medical advice. So even if he does not request, it is your duty to give discharge summaries to doctors, to patients leaving hospitals against medical advice. Similarly, if your hospital is advertising an ambulance facility to ferry patients to and from the hospital, and if he is paying for it, there is no reason why you should refuse. Just because he is not complying with your advice to continue to treat in the hospital does not mean you will refuse ambulance facility. That also has to be complied. So whatever things that you promised and which are available and he is demanding has to be given. So it's something like, you are now already covered under the Consumer Protection Act, and the patient is a consumer, and consumer is God. Whatever God wants, you have to give. So you cannot refuse. This is for medico-legal as well as non-medico-legal situations. Employing of non-MBBS doctors in hospitals engaged in services of modern medicine. Is it legally allowed? I would say yes. To some extent, yes. You can allow in any role except that they are not prescribing drugs or handling patients directly. So especially in medical legal circumstances, don't allow if you are working in a private setup, in a corporate setup, where they employ Ayurvedic or homeopathic doctors as floor medical officers. Don't leave medical legal case handling to them. You will be in trouble because they are not entitled to handle cases at all, leave alone medical legal cases. So let them, so they should not be handling them. Be careful. Your should be they will be handled by the MBBS doctors only. And finally, not discharging the patient for fees or refusal to hand over dead body for want of deposit of fees. Is it ethical or legal? Because doctors say once the body is handed over, the family will not come back to pay me the money, my dues, and my dues are there. So what should you do? It is neither ethical nor legal to retain the body or not handing over death certificates, MCCD. So you have to do this. This offense is punishable under Section 127 of the Bharatiya Nyaya Samhita, and which defines wrongful confinement, and it can lead to an imprisonment of up to 5 years, 1 year to 5 years, or punishment of 5,000 rupees to 10,000 rupees, or both. So that is the extent of punishment that can be meted out to the doctor. So be very careful in such cases. I am done with my talk. So if you have any questions, you can put them on the chat box. I'll try to explain as much as I can. And if you have any suggestions, if you have any comments on my talk, I'll free and open to receive them. So much for information.
Thank you, sir. Thank you so much for such wonderful presentation, completely situation based, which is of practical importance. There are few questions. So now I hand over to Dr. Utsav to just discuss few relevant questions with you. Later on, I think some other queries may be addressed in later. Yes, sir.
Good afternoon, sir. Dr. Swapnil Mishra has asked, sir, what is witnesses asked for knowing about the procedure or the history before giving consent, and they are not willing to give consent if not being made aware of the history?
They are told that they are witness to the signature, and in case they are asked, they only need to tell that we only have seen this person putting their signature here. We do not know anything about the thing written above it. we are not made aware of that. And they will not be at fault. The court will not find fault with them because they are only witness to signature. If they still don't want to do, you can't force them. You can have to find one more witness.
Okay, sir, second question by Dr. Thomas. A girl child must be examined by female doctor, yes or no?
Yes, a POXO case, always POXO cases, and there are only two situations as far as I know in law where a female medical practitioner is mandated to examine a female patient. One is POXO survivor has to be examined by a female doctor, and the second is a arrested accused woman. A woman who is an arrested accused will be examined by a female lady medical practitioner only. So in these two circumstances, yes. Otherwise, it can be a male person in the presence of a female witness.
Sir, Dr. Ravi asked about in context of the MLC cases that what about wild animal attack cases? Are there
Yes. Yes. The reason why we make these cases as medico-legal is so that the family can avail compensation in case of damage, in case of permanent disability or damage to the patient. They don't need an autopsy, so a doctor's certificate will suffice. But if in case the person dies, they ask the procedure laid down says that you need to enclose a copy of the autopsy report, for which purpose a medico-legal case is registered. So what we have done here is only when a person, say snake bite, if the person has died, only then we make it medico-legal. We do not make it medico-legal when the person presents to the hospital. If he is discharged, fine. But if he is not discharged or he dies in the hospital, then we make it medico-legal. We inform the police, we get an autopsy done so that the family can avail that compensation paid by the government.
And sir, last question by Dr. Chirag Varmora. Within how much time doctor should inform the police for the MLC, and if as practitioner and then refer to higher center for admission or specialist opinion for emergency, then who should inform the police for the MLC?
Yeah. Time is not defined anywhere. How much time? Reasonably, it has to be immediate. Reasonably immediate. Most hospitals have a police chowki in their premises, so it won't take much time. And if you don't have it, you can have the local police station phone number, and you can call up the police station and inform them, and take the DDR number from them and note that on the file. Your information is done. If they refuse, you can call upon phone number 100. You can give your intimation saying that the local police station is refusing, and you inform the police, and you can take the number from them and you can record. So that is done. So it won't take much time. So don't think that, unless you are too busy with so many patients, but then still in that case, you can depute one nursing officer or an attendant to inform the police in such cases. So it's not a big matter. As far as giving first aid and referring is concerned, if you are altering with the wound, if the wound has been altered and you have sent the person, say even cleaning of the wound is alteration, because if there's any foreign material that has been removed from the wound, so it is your duty to inform the police. It is your duty to prepare the medico-legal report. It is your duty to go to the court. You are referring him because you are just wanting the person to have a better treatment. But medico-legally, you have manipulated the wound, and the next doctor would perhaps not be in a position to give that opinion which you would be able to give because you were the first person to look at that wound. So I think it is you who would be giving the intimation, you would be preparing the medico-legal report, and then you would be referring the patient to the next hospital.
Okay, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir. It's a wonderful, informative presentation. And the chat box is full of compliments, as you can observe. And there are some other queries as well, because this is such an interesting presentations where you have tried to highlight the practical scenarios through the situations and try to convert this whole presentation rather than a didactic lecture into a question answer based uh, session through this online mode. So for that, sir, we are grateful to you for
Thank you.
clarifying the most of doubt related to the medical legal cases. As a token of appreciations from the AIIMS Rajkot, sir, please accept this small memento from our end,
Thank you
and
so much.
will ensure, sir, that this will reach to your address safely.
Thank
So,
you.
sir, please. Thank you so much, sir. Thanks a
I try
lot.
to answer the questions in chat box so that people are not disappointed. So you can
Okay.
continue with the next session.
Thank you, sir. Thank you. So, in continuation of this ongoing informative CME, we have our last session by Professor Dr. Jayanti Yadav, madam. Madam, good afternoon. Madam, am I audible? Jayanti, madam?
Yes, madam, unmuted.
मैडम आप अनम्यूटेड हैं.
Madam, you can speak now, please.
ये चिंतन प्रेजेंटेशन मोड पे लगा बेटा. मैडम, you are unmuted.
Can you hear me now?
Yes, madam. Yes.
Okay. I'll just share my screen. Okay. I'll just share my screen. Okay. I'll just share my screen. Okay. I'll just share my screen.
Madam, madam, I think you have joined, madam, from two system. Request to
Yeah.
leave audio from one system. I think this is the yes. Okay. But from this there is no voice. Hello, madam.
Hello, madam. Am I audible?
And sir, I request to stop the screen so madam can share later on. Krishna sir.
So, what is he saying?
प्रद्युमन भाई,
हाँ हाँ.
एक बार कोऑर्डिनेट कर लीजिए ना मैडम से.
यस यस, नहीं नहीं, मैं बात करता हूँ. यस, मुझे शेयर उनका नंबर शेयर कर दीजिए ना.
हाँ, आपको शेयर किया मैंने.
हाँ.
Jayanti madam, you need to share the PowerPoint presentation mode.
नो एक्चुअली सर ने स्क्रीन शेयर किया हुआ है, वो स्टॉप करेंगे तभी होगा मेरे ख्याल से. सर
Okay.
का स्क्रीन शेयर अभी तक चालू है.
Chowli sir, can you hear? Are you on the board, sir?
Yeah, I'm just doing it. Just 1 minute. Stop share. Yes. I
Yes,
have
sir.
stopped.
Please.
Sorry,
Yes.
sorry.
Okay,
यस
sir.
यस. ओके.
Done.
Jayanti madam, now you can share the presentation mode. Sir, आपको फोन करना पड़ेगा.
वीडियो। मैडम आपका प्रेजेंटेशन दिख रहा है? So Pradyuman ji, please coordinate with Dr. Jayanti. Meantime, just let me introduce the topic with our participants. This is last topic of the day where we are going to talk about consent in clinical practice. So in this topic, Madam will try to cover certain important aspects pertaining to the consent. As we all know that in our day-to-day practice, where we are dealing with the patients either on the OPD basis or IPD basis, or when we are involving the patient for particular surgery, there are regulatory requirement for taking the consent. So in this context, please try to understand that there are different types of consent which you can correctly practice during your OPD setting and IPD setting. But at the same time, we need to be careful that there are certain things which we understand about the consent, which we can practice only in the when we are doing some intervention or procedure. So there is a concept about the informed consent, and Dr. Chavli also talked about there are informed consent and informed refusal in context to the medico-legal cases.
Am I audible now?
Yes, madam. Yes, madam, you are audible. Your voice is breaking, madam. Probably.
Am I audible now?
Yes, madam.
And is my screen visible? I can't see my sharing.
No, madam. Now it is visible.
Now is it visible?
Yes, madam.
Is it visible now?
Yes, madam.
Yeah.
Please proceed.
So shall I start?
Yes, madam. Please start.
Okay. So thank you so much, Dr. Sanjay and your team, for giving me this opportunity. It's been a pleasure here, and listening to the previous speakers has been a wonderful time. My topic, I'll straight away come to that because the time is running short. So it is consent in the clinical practice, and as you have already heard about the two speakers, that consent is one of the probably the main pillars where the most of the negligence cases arise or they start from. Whenever there is a lack of communication, there is lack of in the patient and the doctor, and the proper relationship between the patient doctor-patient relationship is not established. There, the consent takes the main role. So I will be mainly discussing about the consent, the types of consent, its definition that most of us do know, but I'll just be briefing through it. And then we'll be discussing about what are the main components of the informed consent and what are the rules, how to take the consent, from whom to take, what to do when we are taking the consent. And then I will be discussing in short about the various medico-legal and the clinical scenarios where the informed consent has a specific rules. So that is how my outline of this presentation will be. As you know, consent is basically an agreement or a compliance or a permission, which is given voluntarily without any compulsion. So the important thing is it should be free and without any coercion or compulsion. And legally, according to Indian Contract Act, it is basically when two or more person agree upon same thing in the same sense, they are said to be consenting. So it should be in the same perspective that they should agree to a single thing. And it must be obtained from all patients before any planned examination, investigation, or procedure. So whatever we are doing to the patient, maybe it's a simple examination or a simple blood drawing of a blood for investigation or a surgical procedure, consent is required. Which type of consent, of course, will depend upon what we are doing. So consent is legally valid when it is given freely and voluntarily, without any fear, force, or fraud, and of course after due understanding for what it is given for and of the risk that it involves. So the patient needs to be informed what the doctor is going to do and what are the risks that can be foreseen. So when we talk of the kinds of the consents, the basically consent is divided into implied and express. Implied is just a contract which is not written, which is just understood between the parties. So without any thing written between them. So it is legally effective because the circumstances or the atmosphere surrounding the transaction make it assume that the contract existed between the parties by tacit understanding, or you can say just by the gestures and the mannerisms that person understood. It is a non-verbal sort of communication, you can say, where the things are implied. Implied consent only exists when for examination when there is a doctor-patient relationship is established. So we must understand that Dr. Rao had already spoken about the doctor.
Madam, Jyoti madam, hello.
This meeting is being recorded. There also, it is not required when he performs examination for life insurance policy or when he examines a prisoner. In such cases, wherever the doctor-patient relationship is not there, naturally the implied consent is not there. Then expressed oral consent is always obtained whenever we are doing examination of any bodily orifices or even when we are withdrawing blood for any investigation. In such cases, express oral consent should be taken. Expressed oral consent simply means that we ask the patient, shall I do this? And when he says yes, then only we proceed for that particular examination or for particular investigation or for that particular act. So this is basically done mainly limited to examination of the bodily orifices or for withdrawing blood or taking samples for certain things. Or you can say taking samples for non-invasive procedures. Then the most important part of the consent, where usually the cases of negligence are put or where the issue comes in court, is basically the written informed consent. So written informed consent should be taken whenever we plan any invasive investigations or operations. And here the underlying principle is that the patient must be free to make a choice or a decision when such choice exists. So if I have two modalities of treatment, then I should be free to choose one, and I should be told that there are two choices available and I should be made available all the choices and also told what will happen if I don't choose any of them. So that is what is the basic underlying principle of an informed consent. So it requires that the patient be explained in non-technical language that what is the purpose of the purpose, procedure, risk, complications of the proposed investigation or the treatment, and he then makes the choice. So that is the essence of having an informed consent. Exceptions of informed consent, in which cases we can waiver or we can get away with the informed consent, is in cases of therapeutic privilege. Therapeutic privilege is a situation where the doctor feels that if some information regarding the medical condition of the patient is made aware to the patient itself, it may further harm his condition. So patients who are very much anxious or who are suffering from some mental personality disorders or some mental illnesses, in such cases, if the disclosure of their mental illnesses are told, then they might not take it well. So in that cases, due to the therapeutic privilege, the informed consent can be withheld. In cases of emergency where the patient is unconscious or he is not in a position to be taken consent for, in that cases the consent word. Many times the patient himself gives the waiver for informed consent. Though this is not very much common in India, but in Western cases this is there. They give in writing waiver for informed consent. So in such cases, if that waiver is present, then naturally the exception for informed consent exists. And in most cases of non-elective treatment, that means whenever the treatment has to be rushed through, or it is an emergency, or it has to be an immediate, and there is no time for informed consent to be taken, naturally the exception for informed. But whenever we are we are not taking an informed consent for whatever reasons, it should be properly documented in the patient's form. So that is the one basic necessity. Even when we are not doing any consent, we are not taking any consent according to the circumstances mentioned, the documentation should be very much proper, so that later on the question of why the consent was not taken does not arise. What is the role of informed consent? When we emphasize so much on taking a written informed consent, what role does it? Consent process serves more than one purpose. It is not only giving the autonomy to the person who's treatment plan, but it also has perspective. So if you can see it through this, the legal perspective is it basically gives a doctor a protection from assault. When you are taking the submission or the consent from the patient regarding any procedure that is being performed on his body, then basically the doctor is protected against an implication of an assault or a battery. So that is one protection which the informed consent gives to the doctor. Secondly, it helps the patients from preventing the unwanted procedures. Because when you sit and discuss with the patient of a particular procedure or a treatment plan, you are also telling what are the options available, and you reach to an agreement to what extent you want this procedure to be done. So you are actually putting a barrier or putting a limit, or you are not allowing the unnecessary procedures or unnecessary investigations that may happen to you. So basically it is a agreement between the doctor and the patient, where they are actually protection to the doctor is also given, and the choice, a legal choice to the patient is also given. Then of course there are the consent gives protection, having a consent anyway, and supports the patient defined goals. So whatever patient, everything in the menu, and he can choose what he wants to do and in what way he wants to go further for the treatment. So that ethical autonomy is given to the patient. That helps. So basically the informed consent helps in protecting the ethical behavior, or helps in the protecting the encourage the ethical behavior of the patient doctor relationship. And then of course the informed consent does have the administrative importance also. It has a documentation that both the patient and the doctor were involved in the informed consent process, so that needs to be documented. And it also provides sufficient safeguards to ensure that nominal fulfillment of ethical and legal requirement has been done. So when you have a document of written informed consent, it simply indicates that there has been some talk, some agreement between doctor and the patient, and both have agreed to certain things. So that is the administrative ease of having an informed consent. So what are the basic rules of a valid consent? So when we are saying that
Madam, your voice. Jayati madam, hello. Jayati madam has left.
and this information or this authorization should be informed. So the doctor informs the patient regarding all the available treatment present, and then the patient may authorize the doctor, no, I choose this, please go ahead with this. So that is the agreement that the doctor and the patient needs to arrive at. And the third thing is the documentation. Whatever the things have been discussed, that needs to be documented. Now, this documentation can be through an electronic media, medical record. It can be a procedure-specific consent form. It can be the information can be given by the patient education material, or many other options which are possible. So there are basically the three parts. One is the who can give the authorization. Authorization should be informed, how the information can be given, and how it is documented. So that is what, when or from whom the doctor can take the informed consent. So the important part is the patient should have the capacity and the competence to consent. So when we say the patient should have the capacity and the competence to consent, that means he should have attained the age of majority, which is 18 years in our country, should have a sound mind, and thirdly, should not be disqualified from contracting by any law, because usually the power or the right of contract is usually withheld when the person is convicted. So if the person is a prisoner or if he is convicted, then he is usually disqualified from contracting by any law. So in such cases, he is not able, or does not have the capacity to enter into a contract, and so also to enter into a consent. So the capacity for authorization is given when the age is more than 18. And our IPC section 89, I am not aware, I am not very well versed with the BNS section, so please you can check, because the section is not changed, only the name is changed in BNS. So the child greater than 12 years can give valid consent for physical or medical examination, but for any performing any procedure, a child less than 18 years cannot give consent for performing any procedure. The consent of the person with parental responsibility needs to be taken. So it could be the parents, or it could be the someone who is the legal guardian of the child, who needs to give consent for any procedure that has to be done. Child greater than 12 years can only give valid consent for examination, not for any procedure on the body. And if the patient is incompetent by the means of age or by the mental ability, or he may be a retarded child, or he may be a mentally ill child. So in such cases, a spouse, adult, child, parent, sibling, or any lawful guardian can give the consent. So consent can be taken from anyone who is legally responsible for that person. But in emergency, as Dr. Chavli also told, in cases of emergency, concept of consent can be waived off, especially when the patient is unconscious. So if the person is brought, say for example, there's a road traffic accident and person is brought suddenly to an emergency, there is no availability of the relative or the guardian, and the patient is unconscious, and there is also lack of time to make them understand because of the urgency of the situation. In such situation, doctor is given immunity from the proceedings from the damage, because the act is done for the overall benefit of the patient. So that is very important, that in cases of concept of emergency needs to be understand whenever informed consent is waived off. So that should be documented also. The procedure was done without the consent because of the such and such reasons. Then there is another term which is known as the loco parentis. In emergency situations, especially involving children, especially the children who are living far away from their parents or the guardians, in such cases, the consent is taken from the people on the spot. For example, suppose there is a school picnic and the children have gone to a far off place, and there something happens to the child and something urgent has to be done. There is no time for the doctor to wait for the relative or the legal guardians to come, or the parents to come. There the loco parentis consent may be given by the guardian who is present at that time, maybe the teacher there, and they can give the consent for the procedure. So that is known as the loco parentis, which is an accepted means. Then the another thing is informed authorization. So when we are saying that the authorization should be taken from a person who is competent, or he has a mental capacity to be competent and the age to be competent, the authorization should be informed. That is the second rule of the informed consent, that when you are taking the authorization, it should be an informed authorization. Informed authorization means the nature and the procedure of the treatment with its purpose, benefits, and effect should be explain to the patient in the language that they understand. So it is always better to use the vernacular language. If the person is illiterate, it is better to use diagrams or to explain in a language or in a way that they understand. If any alternative to the treatment is present, that should be told to them. Any outline of substantial risk, any foreseeable risk, that should be told to them. And adverse consequence of refusing the treatment should also be told to them, because many people are afraid of getting surgery done or maybe getting operated upon. So they should also be told about what will happen if they refuse the treatment. And even then, if they are refusing the treatment, their autonomy should be respected. So that is the whole essence of informed consent. And when we are explaining the substantial risk, one should remember that if we go on explaining the risk, the list may become endless. So the common foreseeable risks are usually explained, but very rare or remote theoretical risks may not be explained, because it might frighten or confuse patient, because when you give them 20 things that may happen because of the surgery, naturally the patient may get frightened. So it is better to give them the 5 most common complications that is likely to arise. And I also found in one literature that remote risk of harm, which is referred to as 1 to 2% risk, need not be told to them, need not be disclosed. But if the risk of harm is substantial or is foreseeable, that is, it's more than 10% risk, then it has to be disclosed. So that is how we can differentiate what risk to be told and what not to be told, because not everything can be told. Then how can you do that? How can you take an informed consent? We who know, we have to take it from or you can take it from a intellectually capable person, or who is mentally capable and age-wise capable. And you also know that it has to be informed. But how does this procedure occur? How you can talk to them? So the important thing is communication with the patient. And the important part is the communication with the patient should not be legally centered, but it should be a patient-centered communication. Because when we tell the doctor about informed consent, usually we see also in the hospital there is only 2 lines written: I have consented for my surgery, I have been explained about the drawbacks or the complications of the surgery, and I agree for the surgery. मुझे बता दिया गया है, मुझे समझा दिया गया है और मैं इसके लिए तैयार हूँ. That is the 2 lines which is written. So that is basically a sort of defense that the doctor takes, and it is basically legally centered consent. And in Samira Kohli case, I will be discussing further this landmark case, which is regarding the consent which came out by Supreme Court in 2008. There they did differentiate between what a real consent versus the informed consent. We always talk about written informed consent, but when we are doing it, we are actually forgetting, or we are actually not doing what a real consent is. So the Supreme Court has clearly differentiated between the real consent and the informed consent, which we will be discussing later on. So when we are talking to the patient, when we are communicating with the patient, this is one approach we can utilize to take an informed consent. We can seek their patient's participation. This is also known as the SHARE approach, SHARE. And this was actually told to me about by my learned friend, who actually introduced me to this approach. And he said and this is a very well-known approach, which is easily rememberable and easily doable also. So first step is we seek our patient's cooperation and participation. We sit with them and help the patient explore and compare the health options. So we give them all the options and assess the patient's values, preferences, and situation, and then reach a decision and evaluate a patient's decision. Now, I'll explain with an example. A friend of mine was actually suffering from a localized prostate cancer. So he went to nuclear medicine person, and he told that yes, this is a very confined tissue. We can do a targeted radiotherapy, and this is a very good case, and you can just do away with the radiotherapy, so you need not go to a undergo a surgery, and these are the options available. But after he said that, the nuclear medicine person referred him to a surgeon, urologist. When he talked to urologist said, see, because your tumor is localized, this is a perfect case for surgery. Because if it is not spread, I will only remove the tumor part, and then maybe you will have a very little amount of surgery that you should be taking part. So in this whole situation, what we have taken the patient's participation, we have helped the patient to explore and compare the health options. So he went to two different modalities, he got the option of two different modalities, and then the patient's values, preferences and situations were assessed. The patient himself assessed, and it was assessed by the doctors. Now patient's preferences and situations was that if he goes with the surgery, he will have to come less frequently for the radiotherapy, and if he chooses for mainly for the radiotherapy, then he will have to come again and again for radiotherapy because it will have a higher amount of dosage. So because he was coming from a very far place, his preference was to get rid of the tumor. So he thought, I will undergo the surgery so that I don't have to come again and again for the radiotherapy because I'm coming from a far off place. Had it been a person who was living here, maybe he would have preferred for the radiotherapy. So this is the essence of giving the informed consent. You give the options and let the patient decide basing upon his own preferences and situation, which situation to adopt. So that is the assessment, and then we reach the decision. Then whatever the patient chooses, you reach to the decision and plan the treatment, and then evaluate a patient's decision. Even evaluation can be done midway between the your treatment plan. After maybe 2 sessions, if he thinks no, it's not working, maybe then he can go for an operation, or it may be the vice versa. So it can be evaluation, and evaluation can be periodic. So that is the share approach, how the informed consent should be taken. So whenever we are doing that, we should develop a practice of involving patient in the decisions. And when we are doing this practice, we should be sensitive to the patient's preferences, and it should be consistently applied to all the patient. And the informed consent is designed systematically to address not only the risks but also the benefits, alternatives, and to what to anticipate before and after the procedure. So if any side effects are there, if any some problems are anticipated, which are common problems, that needs to be told ahead. And it is also designed to ensure that the decision making capacity of the patient or surrogate is free, voluntary, and free of undue influence, and they always take the decision after thorough comprehension. So that is very important. So you can also ask the patients the questions whether they have understood and to what extent they have understood the thing. Then explicitly establish the of care and prioritize them in context of other patients' life goals. As I told you, many people, it may be the finance which may be the limiting factors. In many people, there may be the distance which may be the limiting factors. In many people, it may be the persons who are taking care which may be the limiting factor. So depending upon their preferences, the treatment goals will, or the line of treatment will differ. So that needs to be discussed, and then a proper understanding of the consent should be taken. Then coming to the third important rule of informed consent, that is the documentation. So documentation is very important because what is not documented has not occurred. That is a famous saying in medical practice. So even in consent, documentation becomes most important. So we have to document the process thoroughly using an electronic medical record wherever possible, or it is always better to use a procedure specific consent form. Now here I would like to say most of the doctors in the hospital, they use a blanket consent. So blanket consent is not good. It is not a authorized way of taking an informed consent. One consent form cannot be taken for all the procedures. So it has to be procedure specific, and procedure specific when that has been discussed with the patient. Patient education material should be there because there are patients who are not educated, who are not well versed with the medical terms. So in that, if the diagrams are there, if the pictures are there, if they are written or electronic mode, whatever they may be, they are more helpful in making the patient understand what they are going through. And narrative notes describing the informed consent process and the goals of care, that can be done. And decision aids for particularly complex decisions, like any cancer treatment for cancers, they are really complicated because it involves surgery, it may involve radiotherapy, it may involve chemotherapy. So all forms, and there are so many uh, permutations and combinations, and all are when you look at the evidence-based practices, all are equally good. The radio therapy will be equally good as compared to the surgery also. So But depending upon the patient preferences and what he wants and what will be the best for his condition, that needs to be discussed. So it becomes a little complex. So the patient needs to be given the option and then decide what he wants. And the consent form should not be confused with the consent process. Now, this is what we are doing, that once we get the sign on the consent form, we think the consent is over. Consent form is just the documentation of the process that has occurred. And as Dr. Chavli said, it needs to be signed by a witness also, so that makes it legally more valid. But one should always remember that consent form is not the consent. It is simply the documentation of the consent. The consent process needs to be done. And after that, the consent form needs to be signed. So that is very important. One should not only get the consent form signed without doing the process. And that is the basic uh, uh, starting point of all the negligence cases. So what are the factors that affect obtaining an informed consent? So these are the practical points where the doctor face the problem in which affect the obtaining the informed consent. The first is the patient comprehension. As in India, we do get poor patient from poor educational backgrounds, where the anything which is to be explained to them has to be done in such a simplified manner that it is very difficult to tell them about a difficult complication. So for that, we can have the picture based information sheets or some image based information sheets, and they can be explained in the vernacular languages so that the patients comprehend. And the patient use of disclosed information. When too much information is done, many of patients may get anxious, they may get very much depressed also many times, because they could not handle the information that is given to him. Many times the disclosed information is not taken for decision making. They simply think it is an administrative jargon which is being told by the doctor, so they simply sign the consent form thinking that this is also one of the prerequisites for getting the treatment done. So the patient autonomy and the use of disclosed information should be balanced. So how you are telling them and in what way they are taking it, that is very important. And then, of course, the informed consent plays a big responsibility and demand on the providers. And in one study, they found out that to give an informed consent to a patient through electronic medium for a urological surgery takes approximately 11 minutes per patient. And this may vary to up to 20 minutes in certain patients. So almost 10 to 12, 15 minutes, if you can say, per patient for just obtaining an informed consent is a lot of time on the part of the providers, which again is one of the deterrents where the informed consent is deterrent for taking the informed consent. And then another factor is physicians meeting the minimum standards. So physicians also, when 2 or 3 patients, they have taken a detailed informed consent, and due to the lack of the time, usually they go back and they say, "Ha, theek hai, ho gaya," yeah, they just get the consent form signed. And many times they just say 2 or 3 things to the patient. They do not give them whole options, and then they get the consent form. And many times they are also biased to a particular form of treatment. So these are the factors which actually affect obtaining the informed consent, and this should be taken into consideration when we are sitting and communicating with the patient to obtain the consent, because these are actually the small things which may lead to negligence or the consumer forum or compensation cases later on in the practice. So this is again, as I was telling about the Samira Kohli versus Dr. Prabha Manchanda case, where the Supreme Court has differentiated between real consent and the informed consent. So the elements of real consent, as told by the Supreme Court in this judgment, were first of it is the patient should give it voluntarily. Now, brief about this case. In this case, this patient, Ms. Samira Kohli, she was actually a 44-year-old female who was having repeated menstrual bleeding, and she had visited her gynecologist. And she was advised an ultrasound and the laparoscopy, diagnostic laparoscopy, which may be converted to laparotomy. That type of consent was taken from her, and she underwent ultrasound the same day, and the next day she was called to do the diagnostic laparoscopy. And consent was taken that this diagnostic laparoscopy may be converted to laparotomy if needed. And she was told just that it was a simple procedure. We will just put a tube and then see what is there, and then we will discuss the treatment plan. So she went, and while she was, the laparoscopy was going on, the junior doctor comes out from the operation theatre, takes consent for extended abdominal hysterectomy from her mother, who is waiting outside the operation theatre, and then an extended abdominal hysterectomy is done. And it is then after the operation is over, then the patient comes to know that her uterus, ovaries, and hysterectomy has been done, and she, after regaining consciousness, she comes to know that this is what has been done to her, for which she was never told, discussed, and she had never consented for it. So this is the case, and in this case, the patient went without paying any due fees to the hospital, and when the hospital sued the patient regarding the payment of the fees, this case went on from High Court to Supreme Court, and the Supreme Court took the cognizance. And when the Supreme Court examined this case, they found that the doctor has done nothing wrong as per the treatment plan. There was no negligence on the doctor that as per the treatment was concerned, because there was a lot of additions. The laparoscopy was not successful, so they had to go for laparotomy, and when the laparotomy was being done, there was so much of additions in the uterus, ovaries, and whole reproductive organs, that they had no choice but to take out the organs out. And considering that she was already 44 years old, the doctors thought, for the benefit of the patient, that this is the best thing I can do, and she just went ahead. So from treatment point of view, the Supreme Court has agreed that there was nothing wrong which was done by the doctor, but because it was done without any consent from the patient, the doctor was liable. So this was where the Supreme Court has given clear guidance regarding, and this is the first case and landmark case where the consent was discussed, the medical consent was discussed in the Supreme Court, and it has given the essence of the real consent. So it says that the patient should give it voluntarily, and the patient should have the capacity and the competence to give consent, and the patient should have the adequate level of information about the nature of the procedure to which he is consenting. And they also said that consent should given only for diagnostic procedure cannot be considered as consent to therapeutic treatment unless it is agreed upon previously. So you cannot say, okay, I'm doing a diagnostic procedure and it will be converted to therapeutic procedure without you knowing it. So that is one thing. And another thing is, consent given for specific treatment procedure will not be valid for getting some other treatment procedure. So if you have taken consent for surgery, that does not mean that I have taken consent for any surgery. It has to be very specific for which surgery I am taking your consent, and we should not deviate from that thing, whatever the treatment plan has been agreed. And only exception to this rule is when the additional procedure, though unauthorized, is necessary in order to save the life of the patient or to preserve the health of the patient. So if it could be proved that it was essential to save the life of the patient, then this can be waived off. So anything which is taken to save the life of the patient is pardonable, that the law agrees. But it does not mean that there cannot be a common consent for diagnostic and operative procedure. Yes, there can be a common consent for diagnostic and operative procedure, provided they are contemplated earlier and then discussed. But there is also a common consent for particular surgical procedure and an additional or further procedure that may become necessary during the course of surgery. So if you are going for a laparotomy, say for an exploratory laparotomy, naturally during the consent itself, taking the consent itself, you can discuss with the patient about removal of the appendix. But without discussing that, the removal of appendix, if you remove the appendix, then that becomes a offense. But if you are already discussing it with the patient and taking the consent for removal of appendix, it is not an offense. So that is what the Supreme Court has told. Then I will just, after discussing the consent and the essence of consent, I will be just discussing how the informed consent varies according to special cases. In medico-legal scenarios, in all medico-legal case examination, consent should be taken. It is very mandatory that in all medico-legal cases does not waiver of consent in any way. In all the medico-legal case examination, consent needs to be taken. And one of the common question that or the dilemma that comes is the drunkenness, whether we should take consent in a drunkenness and whether the drunk person is competent enough to give consent. So here the rule says that the consent should be taken. Consent should be taken unless the patient becomes unconscious and is incapable of giving consent. Then only the consent can be waived off, or the next of the person or the surrogate consent can be taken. But otherwise, the consent from the drunken person should also be taken. And as you know, autopsy, medical legal autopsy does not require consent, but clinical autopsy does require from the next of the kin. Sexual intercourse, consent is given by a female above 18 years of age. And for the examination of the sexual assault cases, consent is taken for, written informed consent is taken for examination and treatment, for collecting the evidence samples, and also for medical legal examination. And these three aspects of informed consent are separate. They are not interdependent on each other. It does not, survivor may give consent for only examination and treatment and may refuse for sample collection and medical legal examination, or it can be vice versa, or any permutation combination. So it is for all the three separate things, the consent is taken separately, and the survivor may give consent for any one of them or not for any of them. So it all depends on her autonomy. So that needs to be respected, and it is done in presence of a disinterested female witness. And for alleged accused also, we say that consent is not required and a reasonable force can be used in cases of alleged accused, but that is not true. A medical officer can examine an accused in a crime who is under arrest without his consent if the consent is not forthcoming. But it is always better, it is always should be a rule that one should go with the consent. One should always ask the consent, and if the consent is forthcoming, one should take the consent and examine rather than using the going ahead without a consent. And in special clinical practices, when we are disclosing the nature of an illness, it should not be disclosed to a third party without the consent of the patient. So any nature of the illness without the information to the patient should not be disclosed to third party. It may be not even to the spouse. And the doctor can disclose a secret without consent only if it is a privileged communication. If it is affecting the society as a whole or a particular as a whole, then only if it comes under the privileged communication, then only it can be divulged. And a patient undergoing trial has a right to prevent the doctor from disclosing his condition to a third party. So that is there. And a convicted person have no such right, and doctor can disclose the matter to the authority. So in a case of prisoners, the police or the prison officer has right to know what is happening with the prisoner. In cases of operation and treatment, the consent of spouse is not necessary for an operation or the treatment of the other. And it is advisable to take the consent of the spouse if it involves danger to the life or impairment to the sexual function or destruction of an unborn child. So this is spouse consent is only required if it is very dangerous to life, or some sterility or destruction of unborn child is foreseen. And when the procedure is made compulsory by the law, no consent is required. So if any procedure is made compulsory, like for example, we were isolating patients during COVID, which was made necessary by the law. In such cases, we were not taking consent. Similarly, medical legal autopsy, the procedure is compulsory by the law, so it is no consent is required. Then coming to professional negligence, consent is not a defense in professional negligence. So this is very important that we usually take a legally valid consent. We are not into patient-centric consent. We are more into legal-centric consent. But again, consent is not in defense negligence. So if the patient is writing that I am aware of the dangers and I am giving consent for the operation, that does not mean that the operation can be botched up. Medical treatment of pregnancy in MTP, any female who has attained 18 years of age and above and with sound mental status can give a consent. And consent of spouse, again, here is not necessary. But if it's a married couple, then it can be taken because it involves the destruction of the fetus. So it is better to take consent but legally it is not required. In sterilization procedure, according to Ministry of Health and Family, now this is very funny and very contradictory also. In sterilization procedures, the Ministry of Health and Family Welfare says that consent of spouse is not required. But when we look at the medical NMC guidelines, it says that in any operation which carries the risk of sterility, the consent of both husband and wife is needed. So it is always better to take the consent of both husband and wife, especially when sterilization operations are there. In cases of blood transfusion, patient should be informed about the perils of the blood transfusion, benefits of the blood transfusion, the purpose of the blood transfusion, and also told whether the transfusion is the only available solution. And even when the patient is not given transfusion, but if he is exposed to other blood, like for example in ECMO, that also needs to be consented. And when person is suffering from some hemoglobinopathies or some sickle cell anemias or something, or undergoing chemotherapy where he needs to receive multiple transfusion for a pretty long period of time, there the consent is obtained only at the start of the treatment and at 5 yearly intervals. So it is not that before every transfusion the person needs to consent, but for the treatment plan that is made, before starting the treatment, the consent needs to be done and it has to be renewed every 5 years. So key requirement is there should be, as with every consent, and there should be shared decision making, which should be documented, and all the risks should be given, should be explained to the patient. And whichever group has been given and how much it has been given must be informed to the transfusion prior to the discharge, and should also be mentioned in the discharge summary. So it should, if suppose a person is given in emergency some blood transfusion, then before he is discharged, he should be told that this much point of blood has been given and this blood group has been given to you, and that should be put in the discharge summary also for the record purposes. And transfusion should only be considered when there is no appropriate alternative, because and the benefit of transfusion outweighs the risk. So that's very important. One should not take it for otherwise. Yeah, can you hear me now?
Yes, madam.
Yeah, sorry for that disturbance. Yeah. So in psychiatry, the consent has a different essence. In psychiatric concept, usually the capacity to consent is assessed by the competence. As I told you, we need to assess the competence of a person, and the capacity to understand the processing of the information that is laid to the patient, and to reach in a rational manner to some conclusion, that is known as competency. But according to Mental Health Care Act, it presumes that all patients with mental illness have the capacity to make decision, and it is now the responsibility of the mental health professional to prove otherwise. So if we look from the eyes of the law, it assumes that every person is mentally capable of giving an informed consent unless proven otherwise. So you just cannot say that the person is drunk, that is why he is not able to make a consent unless he is unconscious. So that is why a Mental Health Care Act also presumes that even with mental illness, all persons are actually able to take a capacity to make decision unless it is proven otherwise from the treatment plan or by the examination. So the therapeutic privilege is used in cases of psychiatric patients, and some information is not disclosed due to the best interest of patient, but then it should be properly documented. So in psychiatric condition, usually the therapeutic privilege is many times used, and it should be properly documented. That is the importance in psychiatric practice. And if the consent process is tailor-made to overcome the cognitive deficits, it becomes more meaningful and practicable in clinical settings. So in psychiatry, many times the way the patient is explained, or way how the cognitive deficits can be overcome, and each consent can be explained in a nice way to overcome the cognitive deficits, that can be tried to make the consent more meaningful. Then I would like to just share with you what NMC says about the consent. So I have not made any alteration to what their guidelines is, because as a doctor we should know what our council says. Before performing any clinical procedure, any diagnostic or therapeutic or operation, RMP should obtain the signed, documented, informed consent of the patient. And in case the patient is unable to give consent, the consent of the legal guardian or the family member should be taken. So it is only when the patient is unable to give consent. And the name of the operating surgeon must be mentioned in the medical record. So this is where many of we have seen that many times only the patient sign is there, doctor sign is not there, and if the in the documentation, if the witness sign is also there, it makes it more legally valid. So it is always better to have a witness also in cases of written informed consent. And in an operation that may result in sterility, consent of both husband and wife is required. So this is as per guidelines of NMC. But the Government of India guidelines in sterilization operation does not say so. But since the council says so, we have to follow. Consent of both husband and wife is required. And in case of emergency, the doctor should try to obtain consent. But if it's not possible, he must act in the best interest of the patient. And medical record should describe the basis of decisions taken in an emergency. So in emergency, if we are using the paternalistic approach and we are making the decision, so what are the basis of the decision of the treatment, that needs to be documented. And no act of in vitro fertilization or artificial insemination should be taken without the informed written consent of the female, male, or the spouse, as well as the donor. So in cases of artificial insemination, consent of male, female, and the donor, that is both the parents and the donor, are required. So what are the common fallacies we see in the consent process? Many times the procedure is considered trivial, so consent is not taken. For example, a simple IND procedure in a minor OT. So incision and drainage simple procedure है, इसलिए consent नहीं लिया, अरे वो तो minor procedure था. So this is not the excuse. Trivial procedure also requires a consent, and one should inform the patient what it involves, and consent should be taken. Consent of the relative is taken instead of the patient, even when the patient is a competent adult. This is a very common practice, but it should be stopped. And as Dr. Chavli also explained, that consent of the relative should not be taken if the patient is competent. Consenting patient is a minor, intoxicated, or of unsound mind, so isliye we don't take consent. So consent should be taken. If it is minor or unsound mind, then the legal guardian should be taken. Consent of the legal guardian should be taken. If he is intoxicated, it should be taken from the person unless he is unconscious. Blanket consent is usually taken. Blanket consent does not hold good in any way. It is not procedure specific, so it should not be taken. Consent for blood transfusion is most of the times not obtained, so it should be taken. Fresh consent is not taken for repeat procedure. So this is very something that is not done. So whenever if there is a laparotomy done and again it needs to be repeated after a few months or few days, then a repeated consent needs to be taken. The first consent for the same operation will not hold good. Procedure related to necessary information is not given, so that is one. If the consent is not informed, it is of no value. Even if the information is given, it is not documented, so that is very important. What is not documented has not taken place, so documentation is very important. And please remember that process is not equivalent to documentation. So only documenting without going through the process is also not good. Consent lacks the signature of the treating doctor, so this is very important. Treating doctor and also witness, both are required. And alterations and additions are made in the consent form without patient signed authorization. So this is something of breach of a contract. Nothing should be added or deleted once the contract has been, or the consent has been signed. So points to remember: consent should be informed and should be procedure specific. And consent should not be obtained during the course of surgery. It should be obtained before. And consent for blood transfusion should always be done. If it is done in an emergency, it should be informed later on, and it should be told in the written in the discharge certificate also. Consent for examining or observing patient for educational purpose is very important, and here usually the video recording, especially when if you are doing it for some clinical research or for clinical trial, the consent is taken. It is usually under the camera, so you have to record it when you are doing it for clinical trials. Consent is taken for clinical trial, and when if you are using the patient for examination or for educational purpose, again a separate consent for that should be taken. Blanket consent is not valid. We have already discussed that, and so rest of the things. And patient, one should also remember that patient has right to refuse treatment. So one can patient has the right to refuse treatment, and he can also have a right to partially accept the treatment. So the patient should be given autonomy on what he can choose, and he can be told about the drawbacks and the benefits of what he is choosing. So even then he sticks that he wants only partial treatment or he wants refusal of the treatment, that should be accepted or that should be respected. And witnessed consents are legally more valid. So this is the things, and these are my references. And thank you so much. And I'm ready to answer your questions if any.
Thank you, ma'am. Thank you for such informative and very good presentation. You have described certain case scenarios and situations where there is a importance of consent is very lucidly highlighted. So now I invite my friends, Dr. Sab, to take up certain specific question pertaining to consent in clinical practice.
Thank you very much, madam. The query number 1 is from the Dr. Praveen that, ma'am, what do we mean by the reasonable force while examination of the patient? Till what degree we can go?
See, this is does not hold good. We should not be using any force, especially the doctor should not be using any force. The section 53 only says that he can, an accused, if the authorization is given by a police person not below the rank of SI, can be examined without consent if he does not give the consent. But our first endeavor should be to take consent from him, and if he doesn't give consent, we need not stop the examination for want of the consent. That is the only thing. I have looked at the BNS sections and also the CRPC section. It does not say anywhere reasonable force. The new section does not say about the reasonable force.
Yes, ma'am. Another query is that a drunken person is sent along with police inquest or letter. Is consent from the person is mandatory?
Yes, consent from the person is mandatory unless it is under the CRPC 53 or the BNS whatever section.
And the last question is, after examination, if it is found that the person under influence of alcohol, then will the consent will be valid?
See, the cognitive functions of a drunken person is not affected. Okay, so even if the consent is valid or not valid, that is for the court to decide. But for us, if the functions are not affected, we should consent from. This is a very common MD questions we always ask and always are asked. If it is how to confuse the candidates, whether we should be taking consent or we should not be taking the consent, what will happen if there is intoxicated. But the right approach is to take consent, whatever medico-legal case comes to you.
Thank you, madam.
Okay.
Thank you, madam. And for such a sessions, please accept a token of appreciation from our end.
Thank you so much. Thank you so much. Highly honored. Thank you so much. It was a pleasure being in this platform. Thank you.
Small memento, we will ensure that it will reach to your address safely.
Thank you so much. Thank you so much.
So, now I would like to invite my friend Dr. Usap to express the vote of thanks.
So, after the wonderful and enriched presentation from all the eminent guest speaker, I take this opportunity and platform to first of all thank respected Executive Director AIIMS Rajkot, Dr. J.D. Puri sir, to permit us and provide all the facilities through our dear administration team, in which our Deputy Director and our administrative officer has helped us a lot and open up all the facilities for the telecommunications. So thank you very much for the setup provided to us. Then I take the opportunity to thanks all the eminent speakers, Dr. Chawli sir, Dr. Dinesh Rao sir, and Dr. Jayanti madam for wonderful session and providing enriched content to all the participants. I thanks all the advisory team in which all the president of our profound eminent associations were joined and blessed us with all the best wishes. Thank you all the team. Then I take the opportunity to thank our Professor Dr. Sanjay Gupta sir, who is also Dean Academics, to take up this initiative and make this CME successful on this platform. I also thank Eco Platform, our Mr. Dr. Pradyuman Singh, for wonderful efforts to make this event very, very successful. He helped us
Thank
a
you,
lot.
sir.
You helped us a lot from the basic setup till registration, certification, online presentation, and all that aspects. So it went very smoothly, thoroughly. Thank you so much for that. I take up this opportunity for all the departmental coordinators and our departmental team to make this event very, very successful. And last but not the least, all the participants, our 800 participants from across the globe, who is attending the session very interestingly, raising the query very diligently, and we appreciate your efforts to provide your valuable time to make this CME very, very successful. Please provide your valuable feedback. After this CME, the link will be shared along with you. Thank you so much for the wonderful sessions, and thank you so much for the CMEs. Thank you.
So all participants will be getting the participation certificates shortly, and also this all sessions will be available on the YouTube. So you can take the advantage of this academic feast. So have a wonderful time. Thank you so much. Thank you.